The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by or cognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Good morning. Welcome to the second day of our spring oral argument session here in the Harrisburg courtroom of our Supreme Court of Pennsylvania at the majestic State Capitol building. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated our 300th anniversary with a special session in Old City Hall in Philadelphia. We on this bench are very proud of our rich history. As architect Joseph Houston envisioned this Capitol building to be a palace of art, I highly encourage everyone in attendance to visit the rotunda, legislative chambers, and governor's reception room with an eye toward the beautifully crafted artwork, particularly the famous Violet Oakley murals installed in 1927. Violet Oakley was the first American female artist to receive a major public art commission. She devoted 25 years of her life to this project, and her murals on the evolution of law in this courtroom are simply spectacular. In 1927, Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we are all here to do. Our court is always pleased to welcome students to our courtrooms. Visiting with us today are 3 students from Conestoga High School in Chester County and a rising junior from Southern Methodist University. Their visit was arranged by Superior Court Judge Megan Sullivan, and we thank Judge Sullivan for bringing the students to observe our arguments. Would the students stand so we can acknowledge you? There they are. Welcome to the Supreme Court of Pennsylvania. I hope we have some future lawyers in the group here, and I would admonish our attorneys to try not to do anything to dissuade these students from pursuing a career in law. Thank you. You may be seated. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we're asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we wish to explore further. I remind you that we do not permit rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Commonwealth of Pennsylvania versus Jesse John Krzan, representing Appellant, Mr. Zach Goldstein, representing Commonwealth, Ms. Tracy P.
Good morning.
Good morning.
Under both the Fifth Amendment to the Constitution of the United States and Article 1, Section 9 of the Pennsylvania Constitution, the prosecution may not use a defendant's decision to remain silent during the preliminary stages of a criminal investigation, such as prior to arrest, as substantive evidence of guilt. In this matter, before appellant's jury trial for rape of an unconscious person and sexual assault, the court colloquied appellant regarding his right to testify. The Commonwealth made an oral motion in limine requesting that if appellant testified, it intended to inquire regarding his pre-arrest silence. Specifically, that prior to his arrest, appellant made an appointment to meet with investigators regarding the victim's accusations, but never attended any such meeting. The court granted the Commonwealth's motion. At trial, appellant commented that a detective contacted him prior to his arrest, but in response to a follow-up question by the Commonwealth, conceded that he did not meet with the detective. We granted aliquotter to consider whether the prosecutor's line of questioning, which elicited appellant's failure to meet with the detective, fell within an exception to the prohibition on commenting on a defendant's pre-arrest silence as a challenge to his credibility or as fair response to his testimony. Please proceed.
Madam Chief Justice, Justice of the Supreme Court, my name is Zach Goldstein. I represent the appellant, Jesse Krzan. We're asking the court to vacate the judgment of sentence and remand for a new trial on the charges for which Mr. Krzan was convicted, which included rape and related charges. In this case, there were two errors that were separate errors from the trial court and the Superior Court. In terms of the trial court misapplied Pennsylvania law in terms of whether or not pre-arrest silence can be used against a defendant solely because the defendant takes the stand and testifies in their own defense at a trial. And then the Superior Court correctly agreed with the rule that pre-arrest silence is not always admissible solely because a defendant chooses to testify under the broader protections of the Pennsylvania Constitution. But the Superior Court did not apply this court's recent decision in Stevenson and found that Mr. Krzan both could open the door and did open the door. So we are asking the court to reverse on both of those. There has not been, with respect to the first issue, there has not really been a lot of dispute once the case got out of the trial court, either in the Superior Court or the briefing for this level, as to what the rule is. And I think all parties have sort of agreed that the rules regarding silence are set forth in Justice Wecht's concurrence from Commonwealth v. Rivera from just a few years ago, which is that post-arrest silence, post-Miranda silence is almost always inadmissible, and that prejudice is nearly presumed, but that pre-arrest silence, the case law has been a little bit more ambiguous. It's generally not admissible solely because a defendant chooses to testify, which comes from cases like Turner and Molina, Turner being in the 70s and Molina much more recent. But there are exceptions. There's exceptions for impeachment with an actual inconsistent statement. So if a defendant...
Mr. Goldstein, let me stop you. Before you get into the substantive issues and the merits of this particular argument, can you explain how this was preserved, the departure claim was preserved at the trial level? Because by my reading of the transcript, you have a situation where the Commonwealth files a motion to eliminate a use his pre-arrest silence, and there was no mention whatsoever of a departure claim. There was no issues. There was no basis under Article 1, Section 9. It was just a blanket Fifth Amendment claim or blanket objection. So how was this preserved at the trial court level?
Yes, Your Honor. So I think there is an important distinction, which is that the Commonwealth did not file a pre-trial motion limine. This is not something where there was something filed in advance, where the defense had the opportunity to research it or brief it, or that they knew that this was going to be an issue coming in. Essentially, the Commonwealth rested their case. The defense called a fact witness who was the defendant's brother, as well as character witnesses. And then when the defense attorney, when trial counsel indicated that his client intended to testify, the prosecutor stood up and had printed copies of Molina and Fisher and argued to the trial judge that solely because Mr. Krzan was going to testify, that opened the door to impeachment with his pre-arrest silence, with the fact that the police had called him and he had chosen not to make a statement. The defense attorney did say, essentially he said, "Judge, I haven't looked at those cases." He referenced having a conversation with another attorney, local attorney, about it, and then he said, "I'm going to object."
You think that preserves a departure claim?
The departure claim?
You think just a simple blanket objection preserves the departure claim?
I don't think defense counsel had the opportunity to make a more thorough objection because of the fact that this was not done in the way suggested by Justice Wecht in the concurrence from Rivera of filing a motion limine in advance, where trial counsel would have had the opportunity to more thoroughly review the law and realize specifically that Molina and Turner have already found that Article 1, Section 9 is more protective than the Fifth Amendment to the United States Constitution. And so I do think because the Commonwealth, so one, I think trial counsel was a little bit, things come up during trial, so I'm not sure ambushed is the right word, but sort of surprised that this issue came up.
You were in trial counsel?
I was not trial counsel, Your Honor.
I'm sure your trial judge trained you much better than that, right?
Absolutely, Your Honor. So trial counsel was not on notice that this was going to be an issue, to have researched it and briefed it. And then the cases that were cited by the Commonwealth, Molina is a case where this court, at least in a plurality decision, found that Article 1, Section 9 is more protective than the Fifth Amendment.
So why should we rely on Molina when that case involved a non-testifying defendant, and it was an issue of substantive as opposed to impeachment? So,
I mean, that is the significant difference with the issue. It's the difference here versus the holding in Molina. I think the problem is that the distinction is really artificial, and that's what this court found in Commonwealth v. Turner, that it's really not about the timing of the invocation of the right to remain silent. It is prejudicial either way. And so both in Turner and Molina, the court found that the Article 1, Section 9 is more protective, applying the Turner is a shorter opinion. It doesn't necessarily go through all of the Edmunds factors. Molina certainly did that. And the real problem with trying to draw this line, which comes from federal case law. In federal court, this is absolutely allowed under the Fifth Amendment, that a defendant can be impeached who testifies with pre-arrest silence.
Counselor, if we were to find this in your favor, but we were to decide that the error was harmless, would that be wrong?
Yes, Your Honor. This is not harmless error in this particular case. Certainly there's cases where it could be. Adams was a case that even found harmless error in post-arrest or post-Miranda silence. I think that one was just post-arrest silence. The problem here is that this case was a direct credibility contest. The complainant was Mr. Krzan's ex-girlfriend. They were still in communication. She had invited him over. She claimed that he sexually assaulted her. He claimed that there was some consensual sort of making out and touching, and that there was no actual rape. He testified. She testified. The only question for the jury was who to believe. There were no other witnesses. Some of the witnesses that that the complainant spoke with after the alleged incident, she had used language where she did not seem to be so certain. She had said things like, "I think he did it," or "he was on top of me," rather than unequivocally, "he raped me." So there were some uncertainties in her testimony. And then there was DNA evidence that was more consistent with Mr. Krzan's version, which is there was his DNA was found in the complainant's underwear and vagina, but it was not semen. And so if there had been the penetration that the complainant claimed, it would have been more likely to be semen. I mean, not definitely maybe, but certainly the DNA was consistent with Mr. Krzan's testimony, as he never denied that there was contact.
But didn't his testimony on direct imply that he actually cooperated with the police during the course of their investigation. So why wouldn't this information be available on cross-examination to impeach or on behalf of the Commonwealth to complete the picture?
So, Your Honor, that is an exception to the rule if the court sticks with the rule from Turner and Molina. And
Justice Weck said that in Rivera, and it's concurrence.
Right. So if Mr. Krzan had taken the stand and said, I spoke with the police, and that's not true, then he absolutely gets impeached. If he says, I cooperated, that's probably enough, assuming he can open the door, which is a separate issue under Stevenson. But if he gets on the stand and says, I cooperated, and the Commonwealth has evidence that that's not true, then he can be impeached. That is not what happened here. What happened here was the prosecutor came to court, said, if he testifies, Your Honor, the trial judge, if he testifies, I am going to impeach him solely by virtue of the fact that he's testifying and he has never spoken to the police before. It's not, I'm going to impeach him if he says something inconsistent. It's not, they've been attacking the investigation, I think I'm allowed to impeach him now. It's, if he testifies, I'm going to impeach him with his pre-arrest silence. Here's Commonwealth v. Molina, here's Commonwealth v. Fisher, which I the prosecutor, have printed out, which really, there is planning involved, that this was the Commonwealth strategy. The Deputy Attorney General had copies of the cases. I think the Deputy Attorney General misread the cases and the trial judge misread the cases. But she said she's going to do it. She was prepared to do it. She was prepared to make the argument, and then she did it. When Mr. Krzan testifies, it doesn't come up on direct. And what he said when he testified was he's being walked through on cross-examination by a prosecutor who is asking the questions, who has said she's going to do this, and he's going through the timeline, and he says, oh, that was around the time the detective called me. It was not the first time that the jury knew that there had, or learned that there had been contact between Mr. Krzan and the detective, because the detective had already testified to executing a search warrant and taking Mr. Krzan's DNA. So this was not something that was not already in evidence. And if the prosecutor had any concerns about opening the door or causing Mr. Krzan to open the door rather than doing exactly what she said she was going to do, the prosecutor would have stopped there. But instead, she follows up with, why did he call you?
Well, maybe, I mean, look, your case is the clear case, right? The witness gets on the stand and the witness says, the defendant says, I told this story to the police, they didn't believe me. That's the clear way that the silence, pre-arrest silence, can come up for impeachment purposes. This case isn't that clear. Right. When he testified in sort of he brought up in his cross-examination answer to a question on a timeline regarding his employment, the contact with the police officer. Why is it unreasonable or here unconstitutional for the prosecutor then to try to complete the circle, to square the circle at that point in time? Well, did you talk to them? Well, you're saying they reached out to you. Did you talk to him? Instead of letting the jury potentially infer that he did have a communication with law enforcement.
So it's the prosecutor that asked these questions and introduced this evidence. I mean, the detective had already testified to meeting with Mr. Krzan.
Yeah, but his answer about talking to the police officer was somewhat gratuitous.
I think it's sort of that sort of ignores the reality of he's sitting there during the motion in limine as the prosecutor is arguing in court that she is going to ask him about his contact with.
No, I know you keep wanting to say that, but I'm looking on what action instead of focusing on what she said she was going to do. Let's focus on what she did.
Right.
Okay. What she did was she asked him about his employment, and he said, "Oh, that was around the same time that police detective so and so reached out to me."
Right.
And you're saying at that point in time, when he brought that up in his cross-examination, that the prosecutor should have just left open the possibility that a juror could infer that he spoke to detectives.
I think the prosecutor, Your Honor, could have followed up with, and that was to get your DNA, and then left it alone at that.
Well, that would be a leading question. They left it open, more open,
Well, it was cross, so I mean,
right. Well, I know, but I'm saying you're saying she should have asked a more leading question.
Right, so I think she said she was going to do something she can't do, and then she did it. And so I think,
I guess that's the question is, did she,
Right.
should I focus on what she said she did, she was going to do, or should I focus on what she did? And I'm looking at the transcript, and I'm trying to say, do I, as a prosecutor, let the jury think that he talked to this detective after he basically said, oh, yeah, that's when the detective reached out to me?
Right.
Because if I'm sitting in the jury box, I'm like, oh, he talked to the detective.
so that's where I think it's not as ambiguous or suggestive of having given a statement as the Commonwealth has argued and the Superior Court found. I think in context where there was already evidence that Mr. Krzan had in fact met with the police to give the DNA that came from the detective, I don't think that this statement implies that he gave a statement to the police. If he had said, you know, I talked to them, I gave them a statement, you know, even I met with them, maybe it gets a little bit closer. But I think, oh, that was around the time the detective called me, doesn't mean that he gave his version of events to the detective. I think the other problem is that under Commonwealth v. Stevenson, I don't think we get there. I mean, the prosecutor, Stevenson said that once there is a clear ruling on a motion in limine, if either side makes a motion in limine or there's an objection and there is a clear ruling from the trial judge, then the parties are essentially entitled to rely on that ruling without losing the ability to appeal. Mr. Krzan could have taken the stand and said, the detective called me, I didn't meet with him, I did not give a statement, you know, I chose not to, and I think we would still be here for the appeal under Stevenson because he had the right to do that.
Well, you would clearly be here. You would clearly be here under Stevenson had trial counsel had done that. But that's not what happened here. I mean, the situation in Stevenson was such that once there was a ruling on the motion in limine, defense counsel put his client on the stand and asked him directly the question so that he was in control of what the answer was.
Yes, Your Honor.
That did not happen here. I mean, that's why what happened here on cross-examination could be viewed as being trying to get around answering the question directly. I mean, he never did confront what happened in the motion in limine.
Your Honor,
Defense counsel did not.
Your Honor, I think the distinction is whether it comes out on direct with defense counsel asking it or the defense affirmatively introducing it, or whether it comes out on cross.
It's not a question of did it come out on cross. The defendant's attorney didn't take any control over the narrative. So what happened on cross-examination was obviously going to happen. There's going to be a follow-up question so that they would get the benefit of the ruling on the motion in limine. I mean, the fact that it was an unclear answer, it's defense counsel's fault that there was an unclear answer because defense counsel never asked the question so that the defendant could have said, yes, he called me. No, I never met with him. Period. End of discussion. But that's not what happened here. So now we're left with a situation. Is there an inference from what he said that he actually met with the police officer?
So, Your Honor, I don't think there's nothing in Stevenson that requires defense counsel to affirmatively do that.
So you disagree with the Superior Court opinion which said Stevenson anticipates a proactive addressing of the issue in the motion in limine?
Yes, Your Honor. So Stevenson is whether or not the claim can still be heard on appeal, whether the claim is waived if the defense introduces evidence.
But you agree with me, had this been taken on in the direct examination of the defendant, we likely wouldn't be here on this issue as to whether or not there was an implication or could the jury have concluded that he met with them?
It would be, I agree that it would be more similar to exactly what happened in Stevenson, which is where the defense affirmatively introduced the evidence themselves. In that case, it was a criminal record, and the defense put the evidence in after the motion in limine.
Let me ask you one more question on harmless error. There was a follow-up question by the district attorney. There was one follow-up question. There was no argument regarding the fact that he refused to, meet with the detective. The court gave a very clear limiting instruction. Is that one question result in an error that is not harmless?
Yes, Your Honor, and I think the limiting instruction is part of the problem. This is a credibility contest between Mr. Krzan and the complainant. I already explained the sort of the defense arguments as to why I think it was a close case. He's the only witness who gets this special instruction of he, that sort of suggests he had some sort of obligation to speak with the police. And that's not the case if the court sticks with the rule from Turner and Molina and what the Superior Court found that the rule is. In terms of prejudice...
So what was the trial court to do? Did trial counsel ask the trial court not to give the limiting instruction?
The trial court should not have allowed the evidence to begin with.
Okay, but now you're talking about the instruction itself being harmful.
Right.
Was there a request that the instruction not be given?
The defense counsel did not. I think at that point, defense counsel was in an incredibly difficult position of having to choose between no instruction, which means it comes in essentially as substantive evidence, which is a problem under Molina and really Molina, or take the instruction, which is still a problem because it's saying that affirmatively saying that this is a factor the jury should consider in terms of evaluating Mr. Krzan's credibility.
That's a difficult choice, I agree, but he didn't object. I mean, at the colloquy he didn't object, and then at the charge conference he didn't object. So how is that objection of the instruction preserved?
He did not object to the instruction, but I think it still factors into whether or not this is harmless error, because the trial court's decision to admit the evidence then leads to that difficult decision, which then leads to the instruction. And I think if the court looks at the language about prejudice, especially from Turner, from Molina, from Rivera and Costa, or the post-arrest cases, the prejudice is enormous. Turner was a self-defense homicide case where there was one question about having not told the police the defendant acted in self-defense, sort of as he's getting arrested. And the court, in that case, the objection was sustained. The court gave a cautionary instruction saying not to consider it at all, but the trial court had denied the request for a mistrial. The jury in Turner even acquitted of the murder and only convicted of lesser charges, some form of manslaughter. But this court still found that the prejudice was so severe that a mistrial should have been granted. And then it's...
Can I ask a question, counsel? By the time you got to the charging conference, did trial counsel have an opportunity to research the law and explain to the court at that point in time why it was error for the court to allow the evidence?
My memory is that this was all the same day. It was a pretty quick trial. So I don't believe it happened on a separate day, but I would have to double check on that. I don't think trial counsel had a significant period of time to do any research here because this was not filed in advance.
See, the trial court didn't have any time to do any research either, and my recollection is defense counsel said, I think they might be right, when referencing the Commonwealth's motion in limine. I mean, what exactly was it that the trial court was supposed to do under these circumstances?
Essentially, defense counsel had said, Judge, I haven't looked at these cases, but like I said, about a month ago, I had a long discussion with this other lawyer, Barney, about this, and I know there's case law. I haven't looked at these cases. I'm going to object however you rule. And I think that's because the Commonwealth put defense counsel in a particularly difficult spot by not filing the motion in limine in advance. And so that leaves defense counsel in the middle of the day being handed cases, being told sort of not so accurately what Molina and Fisher say. You know, Fisher is an impeachment or fair response case that certainly you can open the door to this. And then Molina just doesn't say this at all. I mean, Molina says Article 1, Section 9 is broader. So I don't know why the trial court read Molina in the way that it did.
But you did say that this was sort of, you didn't say surprise, but you're saying that they made the oral motion in limine. Wasn't that in response to a disclosure that the defendant was going to take the stand?
Yes, Your Honor.
When did that happen?
So the Commonwealth rested, the defense called a fact witness, the character witnesses.
When did the defense notify the prosecutor that they were going to call the defendant to the stand to testify?
I mean, I assume I think right before he testified.
Which prompted the motion in limine, oral motion in limine.
Correct.
So why would the Commonwealth have filed an oral motion in limine or filed a written motion in advance of trial if they didn't know the defendant was going to take the stand?
Your Honor, if the Commonwealth thinks the rule is that they can impeach any defendant who takes the stand, which I think is a pretty novel position, I mean, there is not really Pennsylvania case law that says that they can do that, then I think the Commonwealth needs to file motions in limine.
So that would be in every case. A Commonwealth would file a motion in limine on impeachment against every criminal case. They would have to anticipate the defense might take the stand and have to give a written motion in advance of trial, so defense counsel is prepared.
I mean, after today, not anymore, you know, if assuming the court reaches an opinion on it.
Wouldn't that necessarily inform the defendant's decision on whether or not to testify if he knew what the Commonwealth was going to cross-examine him about?
So I think it potentially does. I mean, if the defendant has a clear ruling, some of the case law, I don't remember exactly which one, it may have been Fisher, a defendant chose not to testify because the trial court ruled that the defendant could be impeached with pre-arrest silence. I don't remember if it was Fisher or not, but there are cases where that was then the issue on appeal, was the defendant said, well, I didn't get to testify because the trial court made this erroneous ruling. Mr. Krzan chose to testify anyway, but he should not have been impeached on this because, it just wasn't the rule. I mean, this isn't, certainly in Rivera, the concurrence sets out the rule. Molina has established that Article 1, Section 9 is broader, and as a matter of federal law, it's okay, but Fisher and Molina, which are the two cases that the prosecutor had printed out for the trial judge, do not say that solely because the defendant testifies, they can always be impeached with pre-arrest silence. And so
go ahead. Do you want to conclude?
And so if the prosecutor is going to advance this type of novel position, then yes, I think the prosecutor should file something in advance so that the parties can be prepared to respond to it and argue it to the trial court, and we don't end up in a situation where there's a conviction for charges like this.
All right. Thank you, Mr. Goldstein. Let's hear from the Commonwealth, Attorney Pietkowski.
Thank you.
May it please the court, Tracy Pietkowski from the Office of Attorney General on behalf of the Commonwealth.
You want to pull the microphone down just a
Sure.
little? Thank you.
Is that better?
Yes, yes.
My kids actually always say I talk way too loudly, so I'll try to
You can't speak
try to
too
pretend I'm talking to my
loudly for
children.
this courtroom.
There is no dispute here about what the Commonwealth believes the rule is, or at least should be, and can be clarified by the court in its opinion in this case. A prosecutor may comment on a defendant's pre-arrest silence for the limited purposes of impeachment and as fair response, not for substantive evidence of guilt.
Are you just saying that blanket now?
No, I
Or
wasn't
is there
done.
an if coming?
No, I wasn't done. And I was going to say, and not merely because the defendant takes the stand. So I think the key is the opening of the door.
That's the question in the case. So what?
Right, so that's the factual question.
Where is right, it's a factual dispute here. So where is the door opening in this brief testimony on cross? Where did Krzan open the door?
Krzan opened the door when, in response to a question related to his employment and the timing of his employment that had absolutely nothing to do with a conversation with the detective, he, on his own, on cross-examination, brings up that was around the time he had the call with the detective. And I think Justice Brobson kind of hit the nail on the head there with the notion that left open a question to the jury about, well, wait a minute, what happened with him and the detective?
Wasn't that question relating to the detective calling him up to inform him about what happened to the victim, and as he testified, give me the information of what the victim had told me and all the incident stuff. He wanted to get my information and meet up with me to do that stuff.
Right.
Right out of the text. So
Which-
I 100% am in line with Justice Weck. Where is the opening? Because the argument that you're saying to me reflects to the original phone call when the detective reached out to him to say, yo, this is what she's alleging on you, we got to talk.
Right, so the detective, it leaves the jury with the impression that...
Did they talk?
Did they talk? Was there a conversation?
Because the question is, and you never met up with him, did you? The answer of the defendant. I did for when he gave me the warrant for the DNA swab. So there is no, he's called him, he didn't meet with him, there was no contact until he came and said, I have a warrant for your DNA. Then he came in. Even with that, this is what the transcript read. I'm confused as to where the door has been opened, even in that regard.
No, I think that he didn't, he specifically did not meet with the detective on another occasion when he was invited to do so. So it's not that his only contact with the detective, and maybe I'm misunderstanding you, but it's not that his only contact with the detective was for the DNA. It's
Where
that,
did he claim, and I'm reading this again for the 10th time, where did he claim he met up with the detective?
it's not that he explicitly claimed it, it's that it leaves the jury with a misimpression that he had a conversation with a detective that he didn't have. And so that's what's being clarified. And I think that's what's being corrected here, the idea that he may have met with them. And I think it's fair for the prosecutor in that scenario, particularly when she's made clear to the defendant that if he opens the door, she's going to go through it.
Commonwealth, again, falling back on Justice Weck, the next line is, the prosecutor, you never met up with him, did you? Because the defendant, I did for when he gave me a warrant for the DNA swab. Prosecutor, right, you didn't have a choice then. Here's the important part, but prior to that, he asked you to come and set up an appointment with you, and you never showed up to give your side of the story. Is that correct? Answer yes.
Right.
How does that imply that he had a prior contact with them or opened the door?
That's the clarification. That's the prosecutor clarifying the previous answers and making clear to the jury. We're not talking about when he said the detective called him, which leaves the jury, the initial part of the sequence, which leaves the jury with a misimpression that he may have had this conversation with them.
He said, did you get a call? Why did he call you? To give me the information about what the victim had told me and all the incidental stuff. He wanted to get my information and meet up with me to do stuff like that. There's no meeting. And so
I'm sorry, there's no what?
In my mind, are you saying that's the phrase or the sentence that opened the door?
Well, I think the first sentence that opened the door was that he called him about all this incident stuff. That kind of implies that there might have been a conversation.
Kind of implies, is that the same thing as an inconsistency allowing the impeachment?
Well, I think in this case, and I thought a lot about this was impeachment, but I do think it was a little bit fair response too. It was
Those
kind
are
of
different.
They are different, but I think in this case they overlap. Because to correct the misimpression is how the impeachment ends up coming in. And I think correcting the misimpression is how the fair response happens. Because, of course, with impeachment and fair response, there has to be something to impeach and there has to be something to be responding to. And so I understand the court's questions, but I want to kind of take a step back and frame the case a little bit first. And that's to say, first of all, the Commonwealth, as I said, we agree with what the rule is and should be and can be formalized in this case, as Justice Wecht explained it in his concurrence in Rivera, and Justice Brobson discussed the cases in Rivera. So it's a factual question. And first, as a matter of fact, the court did not issue the ruling that defendant is saying the court issued. The court issued a very limited ruling here that was not a blanket per se. If he testifies, you can ask him about his pre-arrest silence.
And you, as the Commonwealth, are not claiming you're not arguing that should be the rule.
No, we're not arguing that should be the rule. We don't think that should be the rule. But the point is that's also not what happened here. And I think that's very evident from the transcript and the way things played out in the court. Now, defendant argues that, by citing Fisher and Molina, the Commonwealth, he at one point pointed out Fisher and Molina don't advocate for that rule. They don't announce a rule of blanket per se admissibility, and that's kind of the point. So when he says this prosecutor, the impression that the prosecutor was in there with an agenda, well, I disagree. She was prepared. She was aware of the facts of her case, and she was ready. Once the defendant indicated he was going to testify, she was ready to be able to impeach him if the opportunity arose. And that's why she presented those two cases. And she did say when she was asking for the court to make this ruling, she acknowledged that it was admitted, it could only be admitted for impeachment or fair response, not as substantive evidence. She specifically said if he opens the door to it, that's on page 251 of the transcript. And then the court, after reading the cases, and defense counsel reading the cases, which, by the way, he had the same opportunities as the Commonwealth to be prepared before trial, knowing that if his client might testify, there might be a possibility of impeachment on this. And then the court says, I guess I'll allow it just for that limited extent, and puts parameters on it, which then...
But the parameters, and in fairness, Rivera had not come out yet, in fairness to Judge Lupus, but at 250, I think it's 252, maybe it's 251, he says, upon perusing the case, decided it's not permissible as substantive evidence, but these cases seem to indicate that if a defendant testifies, that it would be a fair response for impeachment purposes. So, I mean, he got that it's impeachment, not substantive, but I'm not sure that he got at that point, and maybe he couldn't have gotten at that point. So you agree on the law now?
We do agree on the law.
In the framing of the trial,
right.
I'm not sure the judge was clear on the door opening issue. So I'm not sure that when I read the trial transcript that ensues after this colloquy on that cross, I'm not sure there's a full grasp on the door opening requirement. Do you think there was?
Well, I think under the totality of all the circumstances, given the case law that was provided, because neither Fisher or Molina says it can come in per se, given that the prosecutor said if he opens the door, and given that inherent in the concepts of impeachment and fair response are, and we say this in our brief, you have to be impeaching something, and you have to be fairly responding to something. And the mere taking of the stand is not something that can be, exercising that right to get on the stand and testify is not something that can be impeached or fairly responded to in that way. I don't think that's a reasonable interpretation. Maybe the judge wasn't as articulate as he could have been. Maybe the prosecutor wasn't as articulate. But when you look at what was said during that motion in limine, and then you look at the way the testimony came out and when, and then you look at the curative instruction, and also, quite frankly, defense counsel's response to all this, it's clear that everyone understood, maybe without saying, the Rivera rule, which didn't exist yet, or being as articulate about the rule, it's clear that that's what everyone understood was going to happen.
Is that correct? It's hard to say. I mean, even in hindsight, but I get the impression from what the trial court wrote after the fact that he was under the impression that the questioning could go generally to the defendant's credibility. In other words, if he had this story to tell that he's telling you now, jurors, why didn't he tell this story to the police in the first place? That kind of general testing of his credibility. Why should we believe him now when he had the opportunity before to tell this story? I mean, I really have a sense that the trial judge had a much broader sense of credibility than you're discussing now or defense counsel is discussing now. Do you agree with that?
I think that's a fair comment.
And that would be incorrect.
It would be incorrect, but I think then that's why you have to look at the rest of what happened in the case. The way the testimony came out, the fact that it was elicited on cross-examination after defendant volunteered the information. It didn't come in. And by the way, on the Stevenson point, I think Stevenson totally doesn't apply regardless here, because even if this court finds that the court erred in the way it ruled, defendant did not preemptively introduce the evidence consistent with that erroneous ruling. And that's what Stevenson's about. That just didn't happen here. It wasn't part of his direct examination. It slipped out on cross after he was presumably a little bit flustered because he had just been caught in another impeachment about his job situation and how often he was actually at work and when he actually was employed versus when he was fired.
But counsel, in follow-up to this discussion of credibility, that's really why trial counsel here for the prosecution wanted this evidence introduced. It's not as though this defendant testified and I told him exactly the same story the first time that he called me. That's not what happened here. This wasn't used as a factual rebuttal to some testimony that he was giving at the time he testified at trial. This was used just generally to go to the fact, well, if he had a good story to tell, why didn't he tell it to the detective at the time he called him? That's not proper, is it?
If that's the way the court sees the questioning,
Well,
then
how
it
else
wouldn't be.
could we see it? Because he didn't say anything other than what we know he said. I mean, he brought it up, then he was asked in follow-up. You didn't talk to him then? The answer is yes. I mean, where is there a factual inconsistency that actually goes to the testimony of the defendant here?
Well, that's where I think it gets into the area of fair response a little bit, and I think there's a little bit of an overlap here. Because as we talked about earlier, when he makes his comment that was when he, and I'll go directly to the transcript, he says, she said, so when did you get your next job? And he says, summertime when it came through. That's when actually Mr. Odgers called me. I was at McLean about all this incident stuff. So that's the beginning where he makes an implication that could be interpreted by the jury to suggest he had a conversation with Dr.
But Detective Odgers had
detective.
just testified in the Commonwealth's case. So
Right, but the detective.
It's not unnatural for the defendant to mention the detective, but then the prosecutor asked, Detective Odgers called you. Defendant testified yes. Prosecutor asked, why did he call you? So, then I guess whatever the defendant answers is going to be responsive to that. And I guess the question here's the question I have in this is when you combine the limiting ruling that the court had made with what the court said later in his opinion that Justice Donahue was asking you about, it definitely appears that the parameters the trial court set here were sort of this generalized credibility impeachment rather than the door-opening factual inconsistency that our law demands. And that you concede here on appeal is the standard. I guess my question then is, on these facts, how can you cram this into the legal structure that does govern?
I'm not suggesting it perhaps isn't a close case, but I think it is reasonable to interpret this portion of the transcript in the way that the trial court and the superior court ultimately did, which is that, when he says Detective Odgers, or Mr. Odgers called me, and she says Detective Odgers called you, and he says yes, the natural question And a fair one, in light of the fact that defendant is the one who brought this up, is, well, why did he call you? But then defendant digs his own hole deeper by saying to give me the information, and he wanted to get my information. And that's where this misimpression could have developed. I mean, we may look back at the cold transcript and think, well, that wouldn't have led me to think there was, I wouldn't have not understood what was going on. But
what misimpression are you talking about? The misimpression that he just merely spoke to him at the time?
Well, which also would imply that because he says...
What else would it imply?
It implies that he gave him information about what happened. Because he says that he called to give me the information of what, and I apologize if I read the name out loud, M had to me and all the incident stuff. He wanted to get my information and meet up with me to do stuff like that.
And then read the next line,
Yeah.
what the prosecutor said.
Right, so then...
And you never met up with him, did you? Why can we not, based upon your argument, imply that that statement by the prosecutor clearly shows to the court that they had never spoken, and they never met, and they never got a side of the defendant's story until the DNA, which is the next question.
Right.
I did for when he gave me the warrant for the DNA swab. So why is that not the rational, reasonable approach to reading this in total?
Well, because then when he says I did for when he gave me the warrant, implies that that's what he was talking about in the first place, which wasn't what he was talking about. He was talking about when he didn't go in and meet with him a separate time.
I disagree with you on that reading. It has nothing to do with, he called him to tell him that he's going to be accused of rape because she just said he raped her and he wants to talk to him about it. And he said, I never talked to the detective about it. And the prosecutor says, you never met with him, did you? Not until he gave me that search warrant. I had no choice. So there was, in that period of silence, where are you finding this implication that he opened the door?
Right. Well, it had already developed. I think by the time he, and we may just have to agree to disagree. I mean, that's the Commonwealth's understanding of the facts here, that there could have been a misimpression when he says that he called him to get his information.
The standard of could have. That's what you're asking this court to do.
Well, I think...
In your opening, you said you would like clear direction from this court. So now, your recommendation to this court is that our clear direction should be the Commonwealth could have?
No, I didn't mean to say that, and if I did,
That's what you just said.
Okay, well, that's not what I'm saying is, when I say could have, I'm talking about what the fact finder, in this case the jury, how they could have interpreted the testimony. And then did the Commonwealth, was it fair for the Commonwealth to correct a potential misinterpretation? And I'm suggesting that that is fair response and that was appropriate on the facts of this case.
The DA could have said, did you ever speak with him between the time he called you and the time you went in for DNA? And that would have solved the issue.
Perhaps, but that's not the record we have. That's not the record we have. So I thought what Your Honor was asking me was, where did the misinformation concern develop? And my point is, I think it developed before the prosecutor said, and you never met up with him, did you? Right, you didn't have a choice then. I think that's just completing the narrative.
If I could follow up on Justice Daugherty's question, it's highly inferential. I mean, the argument you're making is that this was fair because some juror could have inferred some cooperation that Krzan did not give. But
Correct.
But doesn't our law require for this to have passed muster? Doesn't our law require that Krzan said, "Yeah, I met with him and I gave him the story, or I told him X, Y, and Z," and then you contradict with the fact that he'd never met with him until the warrant?
I don't think it does, because I think the concept of fair response, in addition to the concept of impeachment, encompasses this situation where there's a false implication.
Counsel, let me follow up on Justice Weck's question. I mean, he said, and he would have had to have said something like, and I told him X, Y, and Z. Isn't that critical? Isn't the ability to impeach with the silent based upon the idea that the defendant actually says something of what he told the investigator during the pretrial interrogation or the opportunity pretrial to meet?
Well, I think that certainly would constitute an impeachment situation, but I don't...
But isn't that what's required in order to trigger this factually responsive impeachment?
To come in by way of the testimony of the defendant, although in this case it did. But the fair response is where the Commonwealth got to correct what it believed was an implication that was made or could have been left with the jury. And so it's a little bit of the two here.
He had a right to remain silent, did he not?
He did, however, let's remember, this was a pre-arrest
see, that's sort of at the heart of what we're talking about here, because this is a pure case of just using the silence against him. It's not a situation where he's misrepresenting to the jury that he was not silent beforehand. This is just, I didn't talk to him.
Well, I disagree on that factual interpretation of the record.
That was the question. See, that was the question. You put the prosecutor put the bunny in the hat here. The prosecutor asked the question, and you never did meet up with him, did you? Answering the question, did you meet up with him as a result of that first phone call? All this defendant did was answer truthfully. Well, I did when he had a warrant.
Right, but after he had opened the door by bringing this whole thing up in the first place.
Okay.
And the truth is, I mean, I think we can't forget, in a criminal case, counsel mentioned the importance of, credibility in one of these cases. First, I point out, yes, the credibility was obviously an important issue in this case, but the testimony of the victim wasn't the only evidence. There was corroborative DNA evidence. There was medical evidence from a doctor at Johns Hopkins.
Did they also find DNA of another individual?
Possibly, but I don't think that's really relevant.
That there were two different types of DNA found in her vagina.
I don't think that's relevant. I mean, this defendant's defense wasn't somebody else did it.
Said that they only found his DNA.
Oh, if I said...
The record to me said, no, they found someone else.
Oh, if I said they only found his DNA, that was incorrect. They did find his DNA, though. My point was there was other corroborative evidence. And I also think we have to keep in mind, too, the Commonwealth does have a burden of proof. That's why we have rules that have exceptions that allow the Commonwealth to introduce certain evidence, even when maybe it would be otherwise admissible. So I think when you look back at this through that lens, and then you also look at it through the lens of, and I think we have to remember to do this was happening in a trial court. And we lose something in a transcript. We lose the nuance. We lose facial expression. We lose gesture. We lose cadence. We lose tone of voice when we're looking at a cold transcript. So I think when the trial court interprets what happened in a way that is not unreasonable on this record, maybe not what we think right off the bat when we look at the cold record, but when we look at it through that lens, which is appropriate, to give that deference to the trial court. I think the balance tips in favor of finding the facts in the way that the trial court did. And I think once you find those facts, there is no error, and therefore there's nothing to correct. So unless the court has any other questions.
No, we understand both arguments, and fortunately, we have a big room in the back where we'll hash all this out. So,
I'll argue both of you.
Thank you.
thank you both. Very well
Thank you.
argued.
Commonwealth of Pennsylvania versus Jeremy Todd Brashear, representing Commonwealth, Ms. Aplt.
Good morning.
Good morning.
Subchapter 1 of the sexual I of the Sexual Offender Registration and Notification Act, or SORNA, requires certain registered sex offenders like Aplt to verify their residence with the Pennsylvania State Police. In this case, Apelt informed police of the street address of the Harrisburg Hotel where he resided, but did not provide his room number, despite being instructed to do so by law enforcement. We must decide whether Apelt was required to include his apartment or room number when verifying his address under SORNA. Please proceed.
Thank you. May it please the Court, Chief Justice Todd. I'm Katie Adam from the Dauphin County District Attorney's Office here on behalf of the Commonwealth. The issue in this case really comes down to an issue of statutory interpretation. And in looking at subchapters H and subchapter I, is there a difference when the legislature wrote address versus residence? It's the Commonwealth's position that when the Superior Court stopped their statutory interpretation, saying that this is clear and unambiguous language, that was an error. For that to be true, the Superior Court says subchapter H clearly requires a complete mailing address. They do that because the legislature uses the term address consistently within subchapter H. And therefore, when they chose to use the language in subchapter I of residence, that clear and unambiguous difference in the language has to mean a difference between address and residence. But there's an error there. There's a problem with that. And it becomes clear-cut when you look through the entirety of subchapter H and the entirety of subchapter I. Because for the statutory interpretation to stop at clear and unambiguous language, then subchapter H would have to consistently use address to mean the same thing. And subchapter I would have to consistently use residence to mean the same thing, and they don't.
Is it ambiguous?
It is.
It is ambiguous.
Yes, and I can point you directly, I think in my brief, I talk about several different sections of H and I, but very clear cut is in subchapter H in section 9799.15 and in subsection G. In that subsection, it is talking about the requirement to update registration within 3 days of a change. And in subsection H, it says change of residence, not address.
If it's ambiguous, doesn't the rule of lenity apply here?
I don't think it does, because we have to go further. Because if it's ambiguous, then we have to look further into the legislative intent of what this means. What did they mean when they put it? Why is this language different?
But in looking at that, isn't the rule of lenity applicable under Commonwealth versus Roberts?
Your Honor, I would believe that it is not in this situation.
It's Title 18. So by definition, it's whether it governs or controls, carries the day or
Right,
not,
but
is
it's
another thing.
applicable.
I mean, you can't deny that this is the crimes code.
It is crimes code, yes.
So the rule of lenity is in play. What weight it carries is
Right.
another question, right?
Right.
Okay.
So then, when we look at it, in that H, they use residence and not address for what has to be updated within 72 hours of a change. So there's no way that address and residence are unambiguous between H and I. So then it comes down to, why is the language in I so markedly different than the language in H? We look at legislative history and we look at what is going on when the legislature drafts this. And I think that is really the key here about why I is written so differently than H.
Would it be that they're making reference to convictions from prior compared to the new date? What was it, December 12, December 2012?
December 20th of 2012.
Could it be that the language specifies that when those convictions that happened previously, we're going to be more liberal, as opposed to now where we're needing an address? Why could that not be the intent of the General Assembly, with the distinction and use of those two words?
So I think the distinction, Justice Doherty, is very close to what you just raised. And the distinction does have to do with that time frame, and that's why there's two different subchapters. But if you look at the language of subchapter I, it's the language of Megan's Law 2 and 3. When the legislature rewrote SORNA to comply with the court's ruling in Muniz, they went back and took the language from Megan's Law 2 and 3 and put it into subchapter I to fix the ex post facto issue of making the registration requirement what it would have been at the time those crimes were committed. It was never intended to be compared to subsection H. It was committed to be compared to Megan's Law 2 and 3.
Well, regardless of that, you know, they're in charge of writing the laws, and they didn't write full mailing address. They wrote residence. So we're left with this ambiguity here, and you're trying to convince us that it has to go your way because of something in Megan's Law?
Well, respectfully, they didn't write full mailing address in H either.
I'm not talking about H. I'm talking about I. They wrote residence. They had the power to write full mailing address, correct?
Yes, they did.
All right.
And in fact,
if I said to you, if you said to me, Justice Wecht, what's your residence? And if I happen to live in an apartment building, maybe my wife will make me move where, I don't know. But if I said, if you said, what's your residence? And what would be the more natural response? It's the Bristol, or it's room 512 or apartment 512 in the Bristol. What's the more natural response?
and I believe the Superior Court speaks to this directly, the natural response they believe would be the name of the apartment building.
Right.
But is the natural response is what is controlling about what is required, and it's not.
Yes.
Why don't you tell us?
If we look at the policy considerations for both H&I and Megan's Law, the requirement here is about accuracy in information because we are trying to notify the public, law enforcement, exactly where a sexual offender can be located. The changes between SORNA and Megan's Law, the look back in before December 20th of 2012 and after December 20th of 2012 have nothing to do with accuracy. They have to do with the scope of what has to be registered. So if we even look...
Why aren't we notifying the public if somebody says their residence is an apartment building? In other words, if you want to notify the public, you know, that stay away from that particular building, the guy gives his building, why do you need his room number?
Well, Your Honor, when we look at, and Justice McCaffrey, if we look at this case specifically, where we're looking at a relatively small rooming house or hotel, it may seem to be clear enough that the Alva in Harrisburg is clear-cut. But this ruling and this definition and what this means doesn't apply just to the Alva in Harrisburg. If we're looking at huge high-rise apartment buildings in Philadelphia or Pittsburgh, is it specific enough to say that they live in a building that contains hundreds of separate apartments? Does that notify anybody where they actually are or where they can be found? Can Megan's Law verify where they are? Can law enforcement verify where they are? Can the public who lives within that building know where they are to protect their children from being around them? They can't.
Why not? The detective in this particular case walked into the building without an address and said, where does this particular person live? And they said, room 106.
In this particular case, yes. They went down, tracked down the owner, said, where can I find this person? Yes. But that's not what Megan's Law is supposed to be.
We're not talking about Megan's Law, though, are we?
We're looking at SORNA, yes. Colloquial Megan's Law, I do mean SORNA. That's not the purpose. The purpose is not for we can go and do all of these efforts to try to find that. It's supposed to be accurate information so that they can be easily found.
But the other side of that is this infraction resulted in a criminal conviction.
Correct.
So, you know, we're talking about a penal statute here, right? We're talking about a defendant being incarcerated for answering a question generally rather than specifically. So I think it's a little more weighty than perhaps the Commonwealth is suggesting.
Well, if you look back at the history of registration for Mr. Brashear, he had previously registered specific information. He knew this specific information was required. He had registered, I think it was his registration at the Daily Bread, like a specific number that was related to his registration information.
But we're not just deciding the case for Mr. Brashear, we're deciding it for the whole Commonwealth as to what is required and what results in an infraction.
I understand that, Your Honor. And I think that we can look back at the legislative intent was to make subchapter I comparable to what a registration would be required at the time the crimes were committed by individuals in that pre-SORNA era. We can look back at what the court said about registration requirements in the pre-SORNA era. We can say, if we're using the same language with the same intent and the same policy background, what did we say back then? Mm-hmm. Is there an exact case I can find on point that talks about apartment numbers? No. However, there are court decisions that talk about the registration requirements under Megan's Law 2 and 3.
But you would concede, counsel, that even if the court agrees with you that was the General Assembly's intent, that there are instances that, regardless of what legislators intended, they just didn't get there. They just didn't push it over the goal line with language that supports the result you desire.
Do I think that there are instances where that is true? Absolutely. Do I think that that is what is happening here? No, because to interpret it a different way just comes out to this absurd result, because the statute doesn't just include this is residence. It says the state police must send notice out.
Counsel, could it be possible that the General Assembly, based upon our decisions in Munez and say Lacombe, thoughtfully lowered the requirement from a full-blown address to, say, a building of residence to comply with less erroneous conditions that we discussed or removed? Isn't that logical, which is why the standard is less?
I would say not, Justice. And the reason I would say not is because if you look at, let's say, the Lacombe decision and that determination of why I is not an ex post facto issue, it doesn't turn on the accuracy of address information. It turns and talks about the depth of information, the fact that post-SORNA we require registration of things that was not required previously. Addresses were required previously. That's not different than what was required. Things like email addresses, usernames, cars, the amount of times you have to show up, in-person registration, all of those things were the things that were different, that did not exist at the time these crimes were committed. The requirement to verify address did exist. So no, I don't think that that is a reasonable reading of this, because even then, even under Megan's Law 2 and 3, the accuracy of information was paramount. And that, I mean, you can look at the court's decision in Willigus, where we're talking about the registration and the requirement of a registration of information for transient people, where the court is specifically discussing how important it is to have accurate information to locate individuals on the registry. That has existed prior to SORNA. So it doesn't make sense that now, when we're trying to correct our post-SORNA and to get rid of the ex post facto, that we're going to make it less than it was before.
You raised an interesting issue in Willigus. Did the court actually say that about our Pennsylvania statute? Because my understanding was that was our courts interpreting the Maryland statute.
So it was. So when the court was deciding Willigus, there was no on-point case law. We didn't have a statute that talks about the registration of transients. And so the court looked for surrounding state opinions, talked about the Maryland case law when deciding how to rule in Pennsylvania. Yes.
Counsel, I want to go back to your ambiguity. What language in subchapter I are you saying is ambiguous?
So in subchapter I, and let me flip my page back to where I have my statutes laid out here. In I, we have several different places where they refer to residence or address, and they refer to them in different ways. And one of the arguments raised by the Aplt is that the notice requirement, which is where one of the language differentiations is, where it says that the Pennsylvania State Police must mail notice to the last reported residence address.
Right. That language would suggest that the defendant or the registrant has to report a residential address.
Correct.
So how is that ambiguous?
So the way that's ambiguous is because
By the way, this is a really odd thing for me to be arguing arguing with, for the Commonwealth to come in and argue a statute is ambiguous, but okay.
I understand that. But, Your Honor, the ambiguity, I think, is, as pointed out by the Superior Court, is not necessarily inherent in subchapter I, but it's the comparison to I to H.
Why are you looking at H at all? The definition of residence is different in H than it is in I. I think, why aren't you arguing H is standalone and I is standalone? Why can't I stand on all fours?
Your Honor, I believe that if you look at it, potentially it could. However,
where's the cross-reference to H for purposes of determining what the General Assembly meant by the word residence in I?
It kind of goes back to, and I'm speaking back to the Superior Court's decision and why they decided the way they did. They compared the legislative language of the two subsections together.
But why? The definition of residence is different in both statutes.
Is the definition of residence different in both?
I believe it is.
I don't believe it is. So, and I actually think when the Superior Court cited to the definition of residence, they meant to cite to I, but they cited to H because the definition is the same.
You think they're identical?
I do.
Okay. Well, I mean, what about 97, 99, 60 and the idea that they're supposed to notify by first-class mail, to the registrant's last reported residence address, meaning what the registrant last reported?
Correct.
So why doesn't that augment the definition of residence, and why isn't that clear that the General Assembly meant claimant has to report their mailing residence address because that's the only way PSP can provide the notice?
Well, Justice, I would completely agree with you. If we look at just...
Well, that's not ambiguity. That's clear statutory language.
Right. And if we look at I standalone, I don't think there is ambiguity.
Right.
However, the way the courts have looked at it up until this point is by comparing it to H.
Yeah, but I don't know why. I mean, that's what I'm trying to understand is, and I'll have to wrestle with that, I suppose. I mean, I understand the whole in pari materia thing, but I is addressing a completely separate group of registrants than H is doing. It was passed at a different time, probably a different act. So I'm trying to understand from a statutory constructive perspective why we are linking the two so closely to divine an ambiguity.
And Your Honor, your rationale, I believe, is legitimate, and that this court could look at I separately because it is so distinctive from what the purpose of H is.
It was passed at a different time.
They are different things. And I think, Your Honor, if you do that, I think that if you look at subchapter I standalone, then there is no ambiguity.
So now you're saying there is no ambiguity. I thought you told me there is an ambiguity.
Only if you compare H and I. And Your Honor, my argument was based off of how the Superior Court had looked at this, and maybe I should have started with we should look at I separately.
Okay, so the Commonwealth's position, this is interesting. So now the Commonwealth's position is, as you're standing here today, now the Commonwealth's position is that residence is not ambiguous?
So
that reasonable people can't disagree here.
So I think that it comes down to how this court determines they must interpret this. Does this have to be interpreted with H and I together as one statute? Or is I looked at on its own?
Well, which is it?
If we look at I on its own, a subchapter that is passed later to correct an issue with SORNA, then it is not ambiguous. The language within I itself tells us what residence is.
There's a reason why I'm asking you this. If it's unambiguous, then all these statutory construction considerations about which you're talking, the purpose, et cetera, all these things don't come into play.
I agree.
If it's unambiguous, we simply apply what the legislature said. But this whole debate here, and what we're going to eventually hear from opposing counsel and the briefs you both submitted, suggests that reasonable people can disagree about what the General Assembly meant here by residence, right?
If we're looking at H and I together, and I will say that I did not consider I separately until raised by Justice Brobson, but I do think that...
Well, that's dangerous.
that in being, hearing a different perspective and a different way of looking at it, that even though I missed the argument in my brief or missed the argument at the Superior Court, that it actually is the right argument. that it is the right basis, that for statutory interpretation, we shouldn't be comparing a later passed subsection or subchapter to one passed previously.
Just one more thing on that then. So, as you're standing here today, you're saying that if someone had walked into this room this morning and handed out a piece of paper to everybody, the judges, the audience, all reasonable, intelligent people, and it said the word residence, everybody would agree that means apartment building and apartment number in the context of multi-unit structures.
In the context of reading the entirety of subchapter I, yes.
Because residence is a definition
Correct.
that is then applied in the substantive provisions of the statute.
Correct.
And one of them is 9799.6b, where it says notice has to be provided to the last reported residence address.
And it's also, that language is also in B.1. It appears actually multiple times. It's in 9799.54 that when this subchapter went into effect, that we were to mail notification for these offenders to do their initial registration to their last reported residence. And there's no way to do that if residence doesn't mean address.
So disregard all that argument about the police having to be able to track people down and neighbors having to know who lives near them. Just disregard all that intent stuff and policy stuff.
If we look at subchapter I as standalone, yes, because then you don't get past the ambiguity in language. Like, there's no ambiguity if I is alone. If it's compared to H, if you're looking at them as a whole and the language across H and I, then there is ambiguity in address and residence. It really comes down to, does I stand alone or does I have to be interpreted in light of H?
Counsel, where do you get the notion that an apartment or unit number is required?
So it comes from the policy consideration and the court's determinations in prior cases talking about the requirement of accurate information and the accuracy of...
If we look at the statute that discusses the public notice that is to be given to people in the area, it says there'll be a posting of the residence, the street address, municipality, county, and zip code of all residences.
Yes.
Okay, where's the unit number? Where's the apartment number?
So I don't...
If it's that critical.
I don't think at that point that it's critical to the posting of notice for like a sexually violent predator, which I believe is the subsection you're referring to. Where it becomes critical and where it becomes that this is what it has to mean is when we talk about the other requirements imposed upon people under subchapter I, and that is if your apartment number is not on there, how are we to provide you notice?
Okay, well that's a problem that is squarely on the shoulders of the SORNA resident. If the SORNA resident doesn't get notice because they didn't provide an apartment number, that's their problem, not the state police.
I think
but let's get back. I really thought, one of your principal arguments was advising the public where these registered sex offenders could be found. And if the website doesn't have to include an apartment or unit number, how can we conclude, and that's what's at issue here. It's not as though this registrant didn't give a street address. I mean, what this registrant didn't do was give a unit number. And if that unit number need not even be posted on the website, how could we hold it as a criminal violation for this SORNA resident not to provide it in these circumstances? And the website refers to the posting of residence. Doesn't include a unit number or an apartment number. I mean, I'm just really struggling as to how we now impose that requirement on this appellee.
And what's interesting is with your exact point, is that the website requires a posting of residence. So is residence a street number?
What he didn't give is his municipality or county. You're not suggesting that's why he's here. He's here because he didn't give a unit number.
Correct, which is the unit he lives in is his residence. The building as a whole is not.
Not according to this.
Which is useful for parents to, maybe keep their children away from an address or a residence, they're not going to have their child wandering around the 7th floor of an apartment building and not the 9th floor. If they know that there are sex offenders in that building, they're likely going to keep their children away from that building.
Unless they live there. What if they live there with their children? And then it becomes a matter of, my children aren't allowed to go to the 7th floor. My children aren't allowed to go higher than this. If they live in the building, where in the building does matter.
Just ask the neighbor, they'll tell you.
But they wouldn't know that. They wouldn't know the answer to your question if they looked on the website.
Actually, Justice Donahue, the apartment numbers are on the website.
Pardon me?
The apartment numbers are on the website.
I don't know why, since the requirement doesn't include it.
The requirement includes
Street
residents.
address, municipality, comma, county, and zip codes of all residences.
And the residence, this is the heart of the argument. The residence is not the 10-floor high-rise building. The residence is the dwelling within that building where the person lives.
Let me ask you a question. Why then does it not say the street address, comma, apartment or unit number, comma, municipality, county, and zip code?
I don't know that I can answer why it doesn't say that. However, I can tell you that we're talking about the definition of residence, which is what is required to be on the registry. And if you pull up the registry, the apartment number is there.
And how do you distinguish the difference between residence and address? Well, so you understand, my frame is a residence is where you're domiciled, where you live.
Right.
An address is a geographical marker telling you where you can find me. So how do you view the difference?
I really don't think there is a difference because my residence, a geographical marker where you can find me, okay, you can find me in a 10-story high-rise apartment building. That's not my residence. I don't reside in that entire building. Where you can find me is the specific dwelling within it.
So what's the purpose of the two distinct definitions then? Why didn't they have residence or address? Or just use residence or just use address?
I think, Your Honor, because when they were constructing subchapter I in response to Muniz, they didn't necessarily say we want this compared to H. They went back and said if we are going to use the language of what was required of registration at the time, they went and used the exact language from Megan's Law 2 and 3. If you look at I and look at the registration requirement of Megan's Law, they both say residence. The court, in the cases on Megan's Law 2 and 3, found residence was address. There's not a direct, what does this mean? But in discussing the registration requirements of Megan's Law 2 and 3, this court consistently said that they must register their address.
Okay, do you want to wrap up anything else, Ms. Adam?
Just the interpretation that residence means something other than your exact mailing address leaves us with a statute that cannot be complied with in any way. We can't have individuals reside at the Days Inn and still be able to send them their notification and expect they're going to get their mail. We can't have residents saying, I reside in a huge apartment building in Philadelphia and expect that the general public or the police are going to be able to find them or protect their children from them. That's an absurd result.
I'm sorry, pardon me, counsel. You say we can't have this, we can't have that. I mean, that sounds like an argument that ought to be made on the floor of those chambers below us here, the House and the Senate. You know, in other words, a legislator ought to say ostensibly ought to have said to his or her colleagues, we can't have this. We need to say, we cannot pass a law that says residence because you're going to have this very problem. We need to say full mailing address. Correct. Residence including apartment number in the case of whatever. But, you know, it's not our job. It's not our job to write words into a statute that they didn't put in.
I recognize that, Justice Wecht, but if you read it as a whole, if you read I as a whole, if we look at just I, it does come down into 9799.60, as pointed out by Justice Brabson, that they do add that language in of address, residential address, meaning that they're required to register it. The language is there if you read that statute as a whole.
Got the language in 979916 B5. It tells you, information provided. Individuals specified in subsection 979913 relating to applicability shall provide the following information, which shall be included in the registry. Number 5, address of each residence or intended residence, whether or not the residence or intended residence is located in the Commonwealth.
Can you give me that specific subsection that you're citing?
B5 at 9799.16.
Point 16, so we're in subsection H. So in H, they use address for that initial registration of what the offender has to provide for the registry. Well, they then, in 9799.15, if you compare it, they then have to update within 3 business days. They talk about all the changes that have to be updated. They say residence. They don't say address. They never say address. So if we're going to say that residence and address are 2 different things, and we look at H, we're then saying that in H, they must provide their address at initial registration, but when they change, they only have to provide their residence. So now we're giving them a lesser when they move. That's why they can't mean the same, they have to mean the same thing. It can't be that residence and address are different things, or H also makes no sense.
Okay, thank you very much, Ms. Adam. Let's hear from Mr. Bradley.
Good morning, Your Honors. Spencer Bradley for the Dauphin County Public Defender's Office. I represent Mr. Brashear. Thank you for having me back again. Madam Chief Justice, may it please the Court. The plain text of the statute and the legislative history of SORNA's subchapter H and I do not demonstrate that treating residence as distinct from address produces an impossible and unreasonable result. And I want to bring us back to the question presented here that the Commonwealth asked this Court for review in. A lot of their arguments dealing today with whether the Superior Court's interpretation was wrong in applying either the Statutory Construction Act or not. Our position would be, at this point, some of the things said today, that's been waived. The question is whether this result, whether you agree with it or not, is unreasonable and unworkable. Essentially, whether it's absurd. And I think the facts of this case demonstrate, no, it's perfectly workable. Why? Because they knew he was registered at the Alva. An officer believing herself to know Megan's Law more than the court, the General Assembly, or anything, went to him and imposed an additional requirement saying, you should do this. Not a PSP officer. Not someone associated with the Megan's Law unit specifically reaching out to Mr. Brashear and saying, hey, this has to be in compliance because of a regulation or something like this. A Harrisburg police officer chose to do that. But to many of the Commonwealth's arguments today and throughout their briefing, is this impossible to work? No. Why? Because they were able to find him. And to Justice Donahue's point, the website. What does somebody see on the website? If we look at the website, under our interpretation, which our position is the Superior Court got it right, is they'd see someone is registered at the Alva or Pennsylvania Place here in Harrisburg or the Glass House in Pittsburgh, or pick a high-rise. They'd see that person. But what else do they see? They'd see their identifying characteristics. They'd see where they work. They would see what this person looks like such that this isn't, oh, who is this person? What do they look like?
Counsel, that's okay, so I agree with you based on the facts in this case, but under your theory of residence, it's so ambiguous that they could just say Harrisburg, Pennsylvania, that's my residence.
I don't agree.
Well, then tell me where the line is. How much detail does the General Assembly require for purposes of one's residence to comply with the statute?
So, and I think the way we get around this is, and in candor to the court, as well as indicated in the briefing, I initially made the argument that it was ambiguous. The Superior Court applied plain text in its interpretation, so it's a disjunctive argument here. But whenever we look at the definition of residence for subchapter I registrant, which Mr. Brashear is, it's a location where a individual resides or is domiciled or intends to be domiciled for 30 consecutive days or more during a calendar year. Whenever you apply the plain dictionary definitions of those words, resides, domicile, things like that, you would get something specific such as a high-rise and apartment building, things of that nature. That's the level of specificity. You need to know
Well, we also have plenty of cases in the election context where residence is a state.
because
I am a resident of Pennsylvania, and that's my residency.
And I think the context between the two questions is different, Your Honor. I think within the election context, the legislature has defined residence in such a way. Here, we're dealing with a specific definition of residence as applied in subchapter H and subchapter I. And the only reason I make reference...
So context matters.
Yes, I think...
What about how, when 979960 says the PSP has to send notice to the last reported residential address?
I wanted to...
Who reports the residential address to the PSP?
So the registrant would provide, let's use Mr. Brashear as an example because those are the terms here. He would provide the ALVA's address, okay? That would be what the residential address would be. Because if you interpret resident or residential as distinct from address, you now have a superfluous problem, that now it is saying address, address. That's what it's...
No, it's saying resident reported, meaning reported by the registrant, residence address, to which U.S. mail can be sent. That's the requirement.
Right. And the place where the mail would be required or could be sent would be the ALVA.
Do we know that?
Yes. And the reason we know that, and it's cited within my brief, and I will direct the court to that, is our friends in the federal government have a specific policy and guidance for how you should receive your mail. And if you do live in a high-rise, best practices would be to put that specific room number. But your mail doesn't go into the void if you put that basic residential area.
Yes, it does.
Well, I've experienced that as well. But per their policy, at least, that is something that they can send it. And to Justice Donahue's point, ultimately, it's still on the registrant. They are colloquied at the time of conviction as to their requirements. They know that failure to follow through with the requirements as outlined and following up with PSP within their registrant window is going to result in liability. So whether or not they receive mail is an entire, I would submit, is kind of a smokescreen as it relates to the actual registrant's ability to receive criminal liability.
Well, no, because you're saying is look at residence as something less than address, less than something that would require the U.S. mail to deliver it. That's your argument. That's what the Superior Court said. The Superior Court said, I understand in this context the issue was missing apartment number or missing unit number, but the legal theory, the underlying rationale is residence does not mean mailing address. Residence means state, county,
It means
Before you argue, acknowledge Justice Brobson is a very smart man, and that's a very good argument.
And I do believe it's a well-taken argument. However, I would submit that whenever we're dealing with, took me aside from where I was about to go with it, whenever we're dealing with residents...
It took me by surprise, too, by the way.
And me.
I think residence isn't necessarily lesser. I think it's different.
That was a bit of an intermezzo.
Yeah. I think it's just
Well,
something...
he got to the nub of it, so.
I think it's just something different necessarily from an address. An address has that specific difference here that Justice Doherty alluded to, whereas a resident...
Doherty.
Doherty. My apologies.
Doherty.
Doherty. Doherty. That you alluded to here, that an address has that specific and potentially legal element there, whereas residence is where you are. It relates to living and
So
where
the
you
only
live.
thing they do need to report is their state.
Within the context, I think whenever you deal with it's the fixed, permanent, or principal home. I think that's the idea here.
My home
whenever
is
you apply
Pennsylvania. My home is Dauphin County. That's my home. My home is City of Harrisburg.
Well, I think it's something fixed. It's fixed for legal purposes as it relates to
I'm registered to vote in the City of Harrisburg.
I think now
That's
we're
my
dealing.
domicile.
And
That's
now
my
we're in an
residence.
Ouroboros here, where now I'm making reference to the fact it's the election code versus, within this definition of
But
residence.
that's the problem, is you want context, and I appreciate you wanting context, but you have to take the definition of residence, and then, because it's just definitional, it's not substantive, right? It's just it's an aid in interpreting where that word appears elsewhere, right?
Well,
It's not substantive.
I would disagree with that. I would-
Definition is substantive in terms of a requirement or implementation?
whenever the legislature has defined residence and
Yeah, but then you look
understanding-
to, in the statute where they use the term.
Yes.
Okay, so in the statute where they use the term, it says reported residential address, meaning reported by the registrant.
Which would simply mean, for PSP's purposes here, whatever the registrant has provided is where they have to send mail.
But it says reported, right, exactly. So at least you would have to then concede, at least it has to be a mailing address.
No.
Because you can't send mail to someone and just say Harrisburg.
Correct. And I think what he provided was a mailing address.
Well, see, I'm glad you said that, because that's a different issue. That could be another reason why the Superior Court could have ruled in your client's favor and just said, the absence of an apartment building, the absence of an apartment number does not render it not a mailing address. But that's not what they said, and that's not what they did, and that's not what you were arguing. Your arguing is residence and address never shall meet. You're arguing that all they have to report to the Pennsylvania State Police is a residence, which is not necessarily an address.
Correct. I think they're different. I think you can have, in the transient context, the definition of residence has specific things that have to be provided to establish where you generally are. I think that's if you're asking for a level of specificity to have a workable interpretation, and it is not my position that providing something like state or city or,
P.O. box.
Yeah.
Well,
You can't provide a P.O. box
Yeah,
because
you
that's
can't
not a
provide a
resident.
P.O. box
That's not a
because that's not
residential
a
address.
That's
not a residential
residence.
address.
And I think that's where the difference lies, is a residence is different in the sense that in some instances it can be as simple as I live at this home. It's a single family home, that's where I live. Within the larger within larger buildings, though, I think the definition of residence still remains that building.
But is it an
Specific-
address?
yeah.
That's what, can you just say, I think Justice Weck mentioned, can you just say, can they satisfy the registration requirement by simply saying, I live at the Alva, and nothing else? No city, no street, no state, I live at the Alva. That's my residence. Can they say that under your interpretation of the statute and comply?
If there was only one Alva in the entirety of the world, then we all knew that it was that, in fact, one location. Yes, but that's not the world we live in. So I do believe for someone to just say, oh, the Alva, for purposes of reporting to PSP, no, I don't believe that would be sufficient. But that's not what...
Counsel, let's talk about context. This report was given in person, correct?
Correct. He went to DCP and local
And what
Dauphin County Prison. And
He was asked the question, what's your residence?
correct.
He wasn't filling out this form by himself without anyone asking him questions, correct?
No, he was, question, answer, question, answer.
Okay, and so what was the reported residence? Was it the Alva,
No,
19 South 4th Street, Harrisburg?
No, he reported 19 South 4th Street, known as the Alva, but he reported the street. He did not just say the Alva.
Did he mention the Alva? Was it?
No, that what started this, and as Detective
Let me just ask the question. I mean, the person who was taking down the information, did they insert the information, the Alva,
No, where the record gets into the fact that it's called the Alva is a
local police officer.
The officer knew that that address was known as the Alva, and the Alva therefore was a rooming house, so she took it upon herself to go there to ensure that the room number was then added back.
I would just want to focus one more time. Your client went to jail, went to prison because he didn't give a unit number.
Correct, and that's
Okay, that's what we're
that's the
talking.
absurdity.
That's really the heart of the issue.
Yes, that was the Commonwealth's theory at trial, was his crime was not providing the specific room number, not that he had absconded, not that he didn't provide the location of the rooming house in general. It was specifically criminal liability attaches because you didn't put room 103 instead of 201.
Could you address the rule of lenity and the ambiguity here?
Absolutely. That was our position essentially from jump, is whenever you're dealing with residents, some of the issues that we've been identifying here of how specific, whenever you're actually talking about residents, that's where the ambiguity comes in. It's not, in just reading the text that there's something internally that's making it ambiguous. It's whenever you're actually talking about it, how specific? What are we dealing with? And if we get there, the rule of lenity kicks in and has to govern at least how it's constructed. It doesn't automatically mean that Mr. Brashear's going to win, but I think the problem is it's not addressed, and it wasn't addressed by the Commonwealth. They entirely skipped over it for reasonable bases from their position. But if there's any question as to that specificity of the requirement when it comes to residents, 50-50, how specific do we have to be? There's a question for that. The rule of lenity and strict construction kicks in, and this court, pursuant to its precedent, has to construe it consistent with liberty. And I want to take it to Wilgus very, very quickly, because that is the only case that this court really talks about this residence requirement under prior versions of Megan's Law. And a few things about Wilgus that I think it should be emphasized is, one, Wilgus isn't dealing with room number or anything like that. Two, the facts of Wilgus is he was initially going to register at a rooming house or apartment building, and the information he had previously provided was just that basic address of the building in question, not a specific room number. And so factually, Wilgus has some distinguishing characteristics. But two, I think Justice Castile's dissent is instructive here because of whenever you're actually talking about residents. To Justice Weck's point, naturally, and I think the Superior Court's invocation of this does speak more to ambiguity than its plain text reading of the rule and its reasoning. Whenever somebody asks, where do you live? What's your residence? It's a natural response to say the general building. The room number may be specific, it may not. It may be helpful. I think everyone agrees here that for purposes of achieving the ultimate goals of Megan's Law, man, it would be great if the statute was written with that level of specificity. Unfortunately, it's not. But, going back to a point...
Counsel, what's the outcome? We apply the rule of lenity, and so then what are we saying that residence means in subchapter I?
I think a rule that would, if I could suggest how the court would write, it would affirm the ultimate decision of the Superior Court, but would hold that residence requires a registrant to provide the fixed general location where they reside. In the instance of a apartment, rooming house, or group home, that is the address of which the building is, but does not necessarily require the room or apartment number. That would be the holding I would suggest to the court.
And the legislature is free to amend that statute to make it more specific if they so desire, correct?
Absolutely. I don't think you would have an ex post facto problem with that, because it is simply adding the specificity to the definition. It's not imposing an entirely new set of liabilities upon a registrant other than specificity, but this isn't the same problems that we ran into in Muniz, where a registrant only had to provide, where they lived, their work, schooling, and now has to, provide every, email that they're using. I don't think it has that same level of burden imposition if the legislature were to go that route.
Counsel, I want to make sure I understand your request. Your position is residence in subchapter I means address, but the only thing you want us to rule on is when it comes to an apartment or a room number, that doesn't have to be included in residence. You have to have an address, but you don't have to have that level of detail. That's a very limited holding.
I think that would be a perfectly...
So residence, in your view, residence does mean address. It's just that apartment number and house and room number aren't part of the address.
Correct. I think it's correct.
Unless the legislature in the future says it does.
Correct. I think, again...
It is a limited holding. It's a limited case.
Yeah,
The
I mean,
client didn't give a unit number.
Yes, I don't think this is the, candidly, I don't believe this is the, sky is falling or Pandora's box situation that it's made out to be, because we saw the effectuation here. And to the extent that someone, within the transient context, I think is helpful. If the scope of that transience and that, definition of residence, and that's why I say it's different rather than, addresses may be your residence, it may not be, and they have to be treated differently in that circumstance.
On that have to be treated, I mean, for you to prevail, we don't need to go as far as the Superior Court, do we? In other words, we don't need to overplay that presumption of difference. I mean, you can have different words that are synonyms. House and home, crime and offense, football and pigskin. I mean, the Superior Court was insistent that these have to mean something differently, and don't you think they maybe sort of overemphasize the presumption of different treatment for the two words?
So, I think this is the difficulty of in candor to the court, the position that I've carved out, in that I do believe they are different, but I believe they are interrelated. They aren't always, distinct to the same degree as the Superior Court lined out. I think whenever you're dealing with the question, in this case, one form of, one registration scheme criminalizes the failure to provide an address. One is failure to provide a residence. Those differences, I think, is what kickstarts, thinking, well, is there a difference within a subchapter I registrant's reporting obligations? And that's where, that limited rule of, if there's a question as to how specific a residence, in order to be in compliance with Megan's Law, is to, report to PSP, it has to err on the side of, well, do you need a rooming number or just the street address of the building? Street address of the building is our position.
All right, we understand. Thank you very much, Mr. Bradley. Thank you both.
Thank you.
Call the next case, Mr. Minner.
Terry Mutchler and Omar Ruben Maxwell Aplt versus the Office of Administration, representing Collins Smith and
No, I'm good. Thanks.
Good morning, Your Honors.
Good morning. Pennsylvania's Office of Administration maintains the Commonwealth's JNet system. You can stand, it's all right.
Sorry about that.
Which is a web portal that enables authorized users to access multiple databases maintained by various independent Commonwealth agencies, such as the Administrative Office of Pennsylvania Courts, the Pennsylvania State Police, and PennDOT. The Office of Administration, through a series of agreements, grants access to JNet to local government agencies and, in particular, to local police departments. In this case, a newspaper reporter filed an open records request under the Right to Know law with the Office of Administration seeking records related to access to the JNet system by a police officer in the employ of the Camp Hill Police Department, which had contracted with the Office of Administration to provide its employees access to the JNet system. The question for our court is whether such records constitute public records within the meaning of Section 506 of the Right to Know law, given the contracts between the Office of Administration and the Police Department granting JNet access. We also are asked to review whether, through those contracts, the Office of Administration has delegated a core governmental function to the Police Department. Please proceed.
Good morning, Your Honors. I'm joined today by, my name is Terry Mutchler, and I am the chair of Obermeyer's Public Data and Public Transparency Law and Public Data. I'm joined today by two of our senior partners at Obermeyer, Corinna Wilson and Paige McDonald, who is the partner in charge of the Harrisburg office.
Welcome.
Madam Chief Justice, Justices of the Court and Counsel, may it please the Court. I'm asking the Court to do two things today. I'm asking you to reverse the Commonwealth Court and specifically hold that the plain language of 506D of the Right to Know law applies agency to agency as well as agency to private vendor. I'm also asking that you hold that the Office of Administration did in fact delegate a governmental function to the Camp Hill Police Department. The path to this conclusion is very straightforward. It's the Statutory Construction Act. Unless there is ambiguity, no analysis occurs. And to draw on just something that the Justice Weck said in the previous argument, it's not the court's job to write in words that don't exist. And that's exactly what the Commonwealth Court did. They wrote in the word private in 506D where the word private did not exist. So statutory construction is what gets us there in our view. There are a plethora of cases that this court has held related to governmental function, Eisman, Volz, Second Chance. For the court to allow the Commonwealth Court decision to stand, in our view, would totally eradicate bowling and what this court in the marquee the marquee Right to Know law case said, which is that it is remedial legislation to maximize access, and it's designed to prohibit secrets, scrutinize actions, and hold public officials accountable for their actions. Under the Right to Know law, there are two ways in which you get records under 506D. One is the actual possession. The second is possession in a third party's hands when there's a contract in which the agency has contracted with a third party to perform a governmental function. In the plainest, most plain speak I can give this court, here's what the end result is. You have Camp Hill Police Department saying, we don't have the records and you're not getting them even if we did. And what you have is the Office of Administration saying, we don't have them and we're not required to go get them. So the whole purpose of the Right to Know law is eradicated and undercut because it leaves the citizen in the cold. Where do you go to get these records?
Ms. Mutchler, you're assuming the records exist.
I'm sorry?
You're assuming that you're questioning your theory about the person is left in the cold assumes that the records that you're seeking actually exist.
Yes, Your Honor, and in this case they do exist because if you take a look at the record with Police Chief Margison's affidavit, he acknowledges that an investigation was done and that there was a report.
Right. So your remedy, but your concern about the theory of the statute is it's designed to get at these records, whether they're in the possession of the agency or the possession of a third party. Here, the statute will work. According to your entire position, if these records exist, if they exist, their existence has been denied. If they exist with an agency. And your remedy is to get that document from the agency, and if the agency won't give it to you, you appeal to the Commonwealth Court. If you believe they're lying and they have the record, you ask for a bowling hearing, and you get your bowling hearing.
Your Honor, here, there's a couple of things. When we went to the Camp Hill Police Department, the Camp Hill Police Department gave us various, as the record will bear out, gave us various answers, whether it did exist, whether it didn't exist, then it did exist, we didn't get it. If you take a look at the affidavit that the police chief did in this case, they in fact pointed us to OA because of the JNet agreement. And so we went to the Office of Administration, and under your theory, strike that, in this scenario, what we're saying is the Office of Administration didn't do its job. The first thing is it didn't conduct a good faith search under 901. And second of all, it just said, hey, we don't have to go get this. When the plain language of 506D says when there is a contract between an agency and a third party, the agency is required to go get that record.
You know, I'm not responding to your statutory construction argument. I'm responding to your parade of horribles argument that somehow, some way, the ruling, if we rule against you, we will be preventing documents from becoming available. You still have the option. You still have the option today to make a request to an agency for the documents that you claim exist.
Your Honor, I want to correct something here because it's an error in the Commonwealth court argument. They said that very thing. The judge in that case said, hey, you could have gone to Camp Hill. We did go to Camp Hill.
But you didn't appeal.
We did not appeal that, Your Honor. We chose the quicker way because we knew that.
That didn't work out. That didn't quite work out.
That didn't quite work out. That is absolutely true.
You lost all those time frames that are available under the right to know law because you didn't.
Well, Your Honor, we do have an appeal to the Office of Open Records in this case. But the bottom line is, as you know, even though this law is designed for speedy access to records, that doesn't always happen to be the case. And where we are, and I think that where the court particularly should focus is on the question of whether or not there was a contract between the Office of Administration and JNet. To your point, there's many ways in which my advice to people, having done this for 25 years, is don't use the right to know law. Just call the agency and try to get the records. So I appreciate your point related to that appeal. However, what I also want to say is there's a parallel track. We could have done that, and we could have gone to OA, but both of these agencies are pointing to the other, and that's the problem. And here, what we strongly feel under looking at Eisman, looking at the plain language statutes, here, what we have is a contract between OA and Camp Hill Police Department. And regardless, Your Honor, respectfully, with whether we could have done this 15 different ways, it still doesn't let OA off the hook.
No, I was responding to your idea that our ruling here will somehow shield documents from production. This is a pure statutory construction question about whether OA has a contract with Camp Hill or Camp Hill has a contract with JNet or JNet has a contract with OA, and whether that falls within that section. That's all it's about. The bottom line is you acknowledge.
So do I win? I'm sorry.
No, the bottom line is you acknowledge that regardless of how we rule on that, you have multiple ways to get these documents.
You do, Your Honor, but and I'm going to move to the point that you just raised because I think it's important, but I also think for the court to understand that the goal is, and the courts have said this in many cases, it's speedy access. And so, sure, we could have done a lot of things, and I appreciate your point, and I'm taking that and moving to the question that you raise on statutory the issue here is statutory construction. These JNet agreements between OA has given out a governmental function, as Judge Cone-Jubileer said. These are not run-of-the-mill contracts. This isn't like you go to Staples and you buy you buy your software and you sign off on whatever they say. This is anything but run-of-the-mill. JNet is an extraordinarily powerful tool, and the whole wellspring of this case, as the court knows from the record, is the fact that a police officer may have misused this in that his texts indicate that his girlfriend asked him to run a JNet search on someone, a total gross invasion of privacy, had nothing to do with, law enforcement action, and there was an investigation. But diving right into the JNet agreements, OA has delegated a substantial portion of one of its core governmental functions, ensuring that government information and this resource is used in a responsible manner, that there's public trust. If you take a look at the three components, there are executive orders, there are management directives, and there are policies. OA, in its briefs, respectfully, have basically said, look, everybody, we just do IT and we do human resources. That's a master class in diversion, because that is not the case. The JNet, I just want to read you a couple of things that come out of this. They control the entire JNet program and platform. They manage the contractual relationships. They create mandatory policies that govern the JNet use. They oversee, they manage, they supervise. They require their users to report when there is misuse. And I pause on that because I really believe it's important for the court to understand that the Commonwealth Court made in its one of its arguments to the in their decision was that you can get this any way that a different way, if you will, to Judge Brobson's point. And they recast the entire reading of 5.0, or just IT, or where they are just HR. And for even though those things might be included, but for OA to suggest that under the plain language of 506D that they don't need to go get this, I think again undercuts the whole aspect of the right to know law. Drilling down a little bit further, I never thought I'd get this far without questions. But drilling down a little bit further, when you look at the language of 506D that talks about when an agency contracts with another with an entity.
Third party. It says third party.
Third party, yes, Your Honor.
Isn't that a key?
Yes, the exact language says, a public record that is not in the possession of an agency but is in the possession of a party with whom the agency has contracted to perform a governmental function on behalf of the agency and which directly relates to the governmental function, and is not exempt under the Act, shall be considered a public record for these purposes. What the Commonwealth Court did is, it took a legislative pen and it wrote in the word private. I want to share with the court that there are many agency-to-agency contracts. We outlined this in our brief. The Department of Environmental Protection has agency contracts with agriculture, the Department of Education with the Department of Health. If the legislature had wanted to say, hey folks, this only applies agency to private vendor, they could have written that in.
Well, then what's the purpose of this? Because there's other provisions of the Act. Specifically, you can request the agency that has the record, because it's presumed public regardless of whether they're doing a contractual function. If you send a request to the wrong agency, that agency is supposed to pass it on to the correct agency.
That's right.
What's this, if this covers those exact same circumstances, what's the purpose?
Well, Your Honor, I think that the purpose is this, if I understand your question correctly. What the Commonwealth Court relied on was Parsons. And in Parsons, I believe that the Commonwealth Court respectfully committed a big error. They said that the purpose, under our interpretation, would be to recast that third party, Camp Hill in this, as an agency. That the purpose is to recast, a private contractor as in the shoes of an agency. So in other words, if the agency contracts with, Company X, and Company X, has a contract with them and somebody comes for the records, Company X actually stands in the shoes of the agency under 506D.
Because otherwise the documents would be not public, because they'd be in the possession of a private entity.
Right, and I will...
It would be accessible under the other provisions of the right to know.
That's right, and that is exactly right, because the only thing that the nexus here is the contract. So a government agency has to contract out a governmental function with a third party. Not a private entity per se, not an agency per se. The legislature specifically used the word third party. Black's Law Dictionary defines party as someone that takes part in a transaction. But back to Parsons. They said that the purpose is to recast a third party as a government agency, and therefore the government agency already exists, and therefore you would get the records. That's a misreading in the analysis of this court. That's a misreading of what Parsons actually says. Parsons talks about reach. It doesn't talk, it talks about purpose, lowercase p, but it talks about reach. And I believe that that distinction is very, very critical, because the reach of the right to know law, and I believe this is on page 34 of our brief, the reach of the right to know law, and in the language of this court, relates to all parties. This court, in the 15 years that this law has existed, could have injected private entities if it, I don't think it could have, but I'm saying this has never come up until this moment. And it has been accepted that parties, third parties, are exactly what the legislature said. And here, third parties, there is absolutely no restriction on a third party being another agency.
And Judge Cone-Jubileer President Judge Cone-Jubileer made that clear in her dissent.
Yes, I would love if this court would adopt Cone-Jubileer with one exception. I don't think the agency met the burden of proof. And the reason that I don't think that they met the burden of proof is back to Police Chief Margison's affidavit, because in item 27 of his affidavit, he says you can't monitor everybody, basically, in plain language, paraphrase there. And what Cone-Jubileer pointed out and specifically underscored, put it in bold, is the fact that that is a key, seminal, marquee piece of the contracts between OA and the Camp Hill Police Department. In Cone-Jubileer's dissent, Justice Cone-Jubileer's dissent, basically she gave you guys an equation. She gave this court an equation: plain language plus a contract equals 506D, and that's what we have here. And I think, as she underscored, these are not run-of-the-mill contracts. OA, another piece that I'd like to dismantle from the majority opinion is the court talked about how the Office of Administration was not in a position to know what exceptions Camp Hill may have invoked. There's a couple of problems with that. First, and it's wrong. First of all, this law, it's not the responsibility of an agency to invoke or to determine exceptions of another agency. Even at the Office of Open Records, when there were security risks at play, the Office of Open Records could not assert an argument on behalf of an entity. But the reason that this fails, this component that OA was not in a position to know what Camp Hill might have done, that's not accurate. Because under 506D, you have third-party notice. And what occurs in a right-to-know law request, the Commonwealth Court has said in Capsh that there's no duty under the law or for the agency to provide third-party notice to an entity. As this court knows, it's a very big issue, starting with Prince and all the way down. And I actually believe, uncorrected, it will upend the right-to-know law. But, and let me just insert here, the solution is this: the Office of Open Records should merely require an affidavit under penalty of perjury require the agency to give an affidavit under penalty of perjury that in fact notice was given. They require affidavits under the penalty of perjury for their assertions on affidavits and factual. So I think that's the solution. But the reason that the majority opinion fails on this point is that Camp Hill was well aware of these that this right-to-know law request was in play. And also, in addition to that, you had the Office of Open Records sending a packet, this is all in the record, ordering the agency to let the third party know.
Counsel, could I ask, I'm sorry to interrupt you, but you just said Camp Hill. Remind me, was the initial request made to Camp Hill Borough or Camp Hill Police Department?
Your Honor, I always get this confused myself.
There's a discrepancy in the papers.
Yes, there is. And the initial request in September of 2022, if you just give me 1 second here, we made a right-to-know law request to the Camp Hill Police Department. It was not a newspaper. It was Obermeyer that filed the right-to-know law request to the Camp Hill Police Department. So that was the initial request. There was much discussion at the Commonwealth Court about that component and the fact that we tried to work it out, quote unquote, with the Camp Hill Police Department and with the borough itself in that regard. But back to the key point in this.
Counsel, before you get to the key point, with whom was the contract with OA? Was it with the borough or the police department?
I believe, Your Honor, let me just double check here. I believe it was with the Camp Hill Police. It is with the Camp Hill Police Department. Okay. And again, if you know, in the plainest, I'm trying to make this as plain as possible. Everybody knew what was on the table here. Camp Hill Police Department knew that we were after the report related to the police officer that may have, used JNet improperly. OA certainly knew that when we went to OA, and OA and Camp Hill, with OA having to give Camp Hill notice of it, everybody knew about this. But again, I come back to the fact that OA, respectfully, did not perform its statutory duty, either under a good faith search. They basically said, hey, we don't have it, but they didn't meet the elements of 901 to demonstrate that, in fact, they did conduct a good faith search, as outlined in the Uniontown cases. And secondly, and this is the more critical piece, is they would have been required to go to Camp Hill and get that. And I want to go back to one other.
So before you go back
Yes.
to anything else, wasn't it their responsibility to forward the request to the police department?
Your Honor, yes, it could have been if they felt that it was in the wrong.
Was it not? I mean, don't they have an obligation to forward the request to the appropriate agency?
Yes, Your Honor, that is true. But in fairness to OA, without conceding a point in that regard, what has been held to date in that regard is if you ask the Department of Corrections for something, the Department of Education has, and they are required to do that. Now, what we do know from the record is that they have indicated, OA indicated, that they did give notice to Camp Hill that this request was there. So
Is
OA...
that the same as telling the police department that this is a request for them to answer?
It is not the same, and it is a cascade of errors in this, in my opinion.
But I guess my question is, if they have the statutory obligation to forward the request to the appropriate agency, why would 5061 apply to a contract with another agency? Because their statutory obligation in that circumstance is already set forth in the statute, which is tell the appropriate agency.
That's a presumption, Your Honor, that it was the wrong agency. It wasn't the wrong agency because under OA and what they do with JNet, JNet, the contract with JNet requires the agency to report to OA when there has been misuse.
Okay.
So ostensibly, they would have had this as well. And also, there's nothing that means that, I mean, we saw this in the Sandusky Penn State stuff. You know, just because one agency had a set of records, other agencies also that were subject to this law had a set of records.
Understood,
and it doesn't.
and that's a good point. Did OA say that no such record existed within their purview?
Initially, what they said to us is, we don't have it, which is, it doesn't exist,
Right.
and we're not required to go get it. But they did not meet the elements to say that they didn't have it under 901, in our view. And also, we have to just take the plain language and the good faith of government officials. There's a 1929 case that says that we presume the government officials are acting in good faith, and the good faith here is there was a relationship between OA and Camp Hill Police Department. And what it said in the contract is Camp Hill was required to give to OA and report any misuse of this. So if you take it on its face, they were required to have this. And to say we don't have it,
Well, that's just,
Wait.
that's just, your argument's kind of going in circles here, because you're, on the one hand, you're suggesting that OA has this responsibility under this JNet agreement to do certain things, and then you're saying that under the agreement, Camp Hill was supposed to notify them and perform the obligations.
well, Your Honor, let me
I'm just
clarify
wondering,
that if I could.
Along the line of what Justice Brobson said, why don't you just go right back to Camp Hill and say either the documents exist or they do not exist, go through the process? You're now suggesting to the court that there's a parallel track that we should order them because there's a contract with another governmental agency, which is this user agreement, to go get the documents. And if they don't get the documents, then you set up a situation where Camp Hill can say, well, these are subject to some kind of privilege. Who's then fighting it out, and why are we wasting governmental resources if you can go right to Camp Hill and then through the Office of Open Records? We seem to be duplicating a lot of taxpayer resources here on documents that may or may not exist.
Your Honor, we actually disagree. We actually think that, that we took the least burden on both the taxpayer and the court and the Office of Open Records. When OA said, when Camp Hill Police Department said, we're conducting an investigation and we don't have this, to Justice Brobson's point, we could have appealed that. We could have done a drawn-out thing, and we would have ended up also at the Office of OA looking for this as well. There's nothing in either the case law or in the law itself that would limit us from going to 10 agencies to do this. We try not to do that, of course. But to what I think the majority opinion was kind of going at is this. This was a case where there was a contract between the two entities. When Camp Hill Police Department said to us initially, well, they said many things, but when they told us that they were conducting an investigation, and that, or and that they also spoke kind of out of both sides of their mouth and said, but we don't have to monitor everybody. We can't monitor everybody. The place to go was the folks that had the key, and for us, the people that had the key was OA. And OA should have had these documents, and
Well, they should have, right? If the contract required Camp Hill to disclose something that existed.
it does.
But you got the answer from OA that said, we don't have anything from Camp Hill.
Yes, but what they did is they took a next step. And that next step was to say, and we're not required to go get it. And that's the whole reason that we're here.
I understand, but didn't you accomplish the task? Give them a document, period.
We didn't establish that, Your Honor, because our argument is under 901, they didn't go through the steps that are outlined in Uniontown to demonstrate to us by a preponderance of evidence under state troopers that they in fact conducted a good faith search.
Right, and where did the Commonwealth Court didn't get to that?
The Commonwealth Court did not get to, what they actually said was that they met their burden under the Margeson affidavit.
They met the Uniontown standard under our mark.
Well, I don't, to be honest with you, Your Honor, I don't know if they actually cited Uniontown. I'd have to, look at that. But I know what they said was they agreed with OA that they didn't have to go.
That's something we would have to address. I mean, this idea of whether they met their burden.
Well, first of all, I think that the way that this gets packaged is this. The most preeminent and critical piece of this is whether an agency, and in this case OA, had an obligation under 506D to go get the records. Because if that fails, if it exists, but they're at least required to go, whether it exists is a whole other animal. And we're not, listen, if it doesn't exist, with all due respect, OA and Camp Hill have a much bigger problem than the right to know law under the circumstances of this case, with JNet being perhaps misused.
You mean spoliation?
Pardon me, Judge?
You mean spoliation?
No, I don't mean that. What I mean is you have a cop here whose girlfriend texted him, we have the text, and says, hey, I want to check on, this is paraphrased, I want to check on whether or not my old boss is involved with this person. He says, babe, I could get fired for that. She said, and then he says, but anything for you, basically, and send me the info. So what I'm suggesting by this is not spoliation, Your Honor, but there's a much bigger issue of the use of this critical system of JNet and being misused as opposed to the right to know law component, if in fact this record doesn't exist at either place. And also the Margeson affidavit undercuts that it does in fact exist because the chief said in item 27 that there was an investigation. But back to the packaging, Judge Brobson, it's this. I believe that the seminal key piece of this is, did OA have to go to Camp Hill to get this? Plain statutory construction is, yes, they did. The Commonwealth Court, in error, in grave error, wrote in words that should not have been in there. So let's say they are required to go. Let's say we all agree with that. But let's say OA says, hey, we don't have it. OA still has a burden under the preponderance of evidence that's written into the right to know law to go look and conduct a good faith search.
And we've covered this, yes.
Right.
We've said this, so I
Exactly.
think we understand. Do you want to conclude?
Your Honors, unless this court has other questions, we're asking this court to adopt what Justice Cone-Jubelier said, with the exception of the preponderance of the evidence aspect, and to reverse the Commonwealth Court and hold that OA is, in fact, required to go get these records, and that a governmental function did, in fact, go from OA to Camp Hill.
Thank you, Ms. Mutchler. You may have actually succeeded in, for the first time, making the Right to Know Act interesting. Thank you. All right, let's hear from Mr.
Wow. Thank you, Your Honor.
Good afternoon, Madam Chief Justice, and may it please the Court. My name is Thomas Howell, Deputy General Counsel here for the Office of Administration. I'm joined here today by Angela Rainey, a Deputy Chief Counsel for the Office of Administration. And, Your Honor, I'd like to first note that the appellants and appellees agree on some primary issues. This is a pure statutory construction matter. The statute, the law on this is very clear. However, the most salient and indeed the most clear provision of the law that controls this entire matter is the provision that has been essentially skipped over by the appellants. 506D begins by saying that a public record that is not in possession of an agency but is in possession of a party with whom the agency has contracted shall be considered a public record. That first line's important. 506D stops in this case because everyone agrees that this record is in the possession of an agency. Camp Hill Police Department is an agency under the Right to Know law.
You're divorcing that first phrase from the context in which it appears, and you have to read that second phrase, with whom the agency, meaning the first agency, has contacted. It contemplates the same agency, not different agencies.
I don't think 506D1 does contemplate the same agency. It talks first about the existence of a public record that is in possession of an agency. That's any agency. The legislature then went on to talk about the agency, a specific agency who has contracted to perform a governmental function.
A public record that is not in possession of an agency.
Yes.
An agency.
That's correct.
But it is in the possession of a party with whom the agency, meaning the an agency previously, has contracted to perform.
That's right. And in this case, that an agency, the agency is Camp Hill Police Department.
Right, no. A public record is in possession of an agency, which would be OA. Well, assuming it exists.
But it's in the possession of an agency under any read of that statute.
Okay, hold on for a second. Let's parse it a little bit. Mm-hmm. A public record that is in the possession of an agency, here the claim is that OA is not in the possession of an agency. Here, not in the possession of OA.
Right.
But is in the possession of a party with whom the agency, meaning OA, has contracted to perform a governmental function.
But you don't even get to that part because the first clause of 506D only applies when a public record is not in the possession of an agency.
But is in the possession with a party to whom that agency is contracted.
But here it's clearly in the possession of an agency. We just disagree as to which agency should or does possess it. It's in the possession of an agency, and that plays so well with the other provisions of the Right to Know law.
You don't think it's agency-specific in context?
It is not agency-specific, and the reason why it's not agency-specific is because this is perhaps one area of the Right to Know law where the legislature thought things very well through and recognized that a record that is not in possession of an agency is instead then in the universe where agencies are referring matters to each other for them to handle within their own obligations as agencies under the Right to Know law.
Your construction is just very straightforward. This section doesn't apply in any context other than where a public record is not in the possession of an agency.
This 506D applies when a public record is not in possession of
Well, it
any
deems- it deems something
agency
a public
whatsoever.
record. It deems something a public record.
Where it's not in the possession of any agency whatsoever. Where it's in
Because
the
if it
possession
is in
of
the possession of an agency, by definition, it's a public record.
That's
and
right.
You wouldn't need D1.
That's right, and that's the only way this all works together. That's why, even if you read an ambiguity into this, and I don't think there is an ambiguity, I think it's very clear here, the public record, it's in the possession of an agency if it exists. It's either in the possession of agency A, OA has testified, averred that they do not possess it, or it's in the possession of Camp Hill Police Department, agency B. So you can stop the analysis under 506D right there. The rest of it simply does not come into play. Even though if there is an ambiguity and you look at giving effect to all of the provisions of the statute, then you move right on to section 502, which provides a process for referring requests from one agency that does not possess a record to another.
Right, so, yeah, and that one, so under that one, why wasn't the request sent to Camp Hill Police Department?
My understanding is that the record shows that there was communication with Camp Hill Police Department. I think in this instance, because there was already so much involvement, a formal referral wasn't made, but it's clear that the statute contemplates a situation where agency to agency interactions occur by referring right-to-know requests, not by this contractual paradigm that the appellants have tried to set up here.
The answer to your question is the record doesn't show that you did it.
Right.
Because it doesn't say send it to the agency. It doesn't put the agency on notice. It says you actually have to send it to the appropriate person.
That's right.
Which is the right-to-know officer.
Right.
And is there anything?
That did not happen. That's right.
That did not happen.
That did not happen.
So you didn't follow 502B1, but they're not challenging your failure to follow 502B1.
That's correct, likely because they had, and all the parties were aware they had already been to Camp Hill Police Department. And what the record does show with respect to Camp Hill Police Department, and this is actually appellant's brief, is that at some point during their consideration of this matter, Camp Hill recognized that maybe they do have the record. That apparently wasn't the first response they took, but either way, that's got nothing to do with OA's responsibilities, which really here are not contractual in nature. The obligations under 506D do not compel any agency to seek out and act as an advocate to retain or obtain records from other agencies that are themselves obligated to do that kind of legwork. The position posited by the appellant here almost attempts to set up a statewide ombudsman or clearinghouse for right-to-know requests whenever there are interagency agreements. And again, appellant has argued to this court that there are varied and numerous agreements and contracts between agencies. There are. That would really place any agency in the position of having to take an extraordinary effort to look for the possibility that there are agreements with their sister agencies and complicate, slow down, and make more difficult what is really a simple process. Justice Robson hit the nail on the head here. There is no reason that this could not have been pursued as to Camp Hill Police Department. They're an agency. They are the agency in the terms of 506.
Before I'm, just to be, I like the compliments I'm getting. This is nice.
Don't get used
fairly
to it.
infrequent. I'm not. But let's just step back for a minute. What if I'm making a request to who I believe is the agency by law that should have the document, and I'm just, this is meant to deal with people off the street. This is not meant to require people to have the caliber of representation that the Obermeyer firm has sitting at council table. And I send a request to an agency, and I don't know that the agency has some sort of an intercooperative agreement that lays off some of its governmental function to another agency for administrative purposes or for whatever. And I send the request to the agency, and the agency says, well, we don't have it. Snicker, snicker. We have this side agreement that pushes that function off to another agency. So we're just going to deny it because we don't believe this section applies. What is the requester supposed to do with that?
That's where 502 comes into play, and that really is where the law, as it is read holistically,
You're saying the obligation, the 502 true obligation would trigger. You would notify the requester, you sent this to the wrong agency, we have an intergovernmental agreement, and boy, that's a lot of trust going on there.
And there always is, with or without an agreement.
Well, no, I agree. I mean, that's a lot of faith and a lot of trust that the public has to put in these governmental actors.
Absolutely, and the governmental actors, I won't say without fail, but in the ordinary and traditional operations of government, take great efforts to identify and provide contact information for those other agencies that might. Remember, the obligation is to provide that information where they may possess responsive records. And every day, conceivably hundreds of times a day, Commonwealth and local agencies do exactly that. They respond to requesters and say, we do not have this information. However, from the context of your request, it appears that you may be seeking records that might be in the hands of the Department of Corrections or the Department of Education. That happens ceaselessly. It goes on in the ordinary course of business every day and is exactly what the right to know law provides for. It is not altered or overcome because a user agreement exists between any of those agencies. Instead, what the law provides for and what should happen is for that requester to go to the agency that's actually got the records. Why add another layer of bureaucracy onto a process?
Because by definition, it's public.
It is.
It's already a public record.
It is. It's presumptively public.
It doesn't matter whether that agency is doing a government function for another agency. It's by definition of public if it's in the hands of the agency.
If it's in the hands of that agency that has possession, custody, and control. That's correct.
Counsel, the appellant argues that a direct request was made to OA because under the terms of the contract with the police department, a report of this incident had to have been filed with OA. And apparently the response to that request was no such document exists?
That's correct. OA simply did not have that record that was sought in its possession, custody, or control. Whether that's because there was no undertaking under the user agreement by Camp Hill, or whether because Camp Hill did not provide that information to OA is something that is outside the record and unknown to OA. But in either case, the affidavit provided by the OA officials demonstrates that they examined OA's records and confirmed that OA doesn't have it. What the appellant wants here is for OA to not only do a double check of OA's records, they're actually asking OA to go out and do a double check of Camp Hill.
Well, I understand that, but that's a different issue. The request was directly made to OA.
Correct.
As an end-to-end government agency that they believe should have had such.
That's right.
Along that line, is it also a possibility in this case that although the police officer promised his girlfriend that he would follow up and do this JNet search, that he in fact just determined that it wasn't something he was willing to do to risk his job?
We wouldn't know the answer to that. That's something that, again, is properly directed to Camp Hill, and that's a very good reason why this request probably ought to have been further litigated against or further pursued as to Camp Hill Police Department rather than OA. That's simply information that OA would not have. In fact, the user agreements even don't get into that sort of level of detail. What we find out from the material that appellant submitted is that at some point Camp Hill discovered that they may have more information than they originally thought they have. It appears that appellant chose not to pursue that and instead went to OA. Again, for reasons that we can't be certain of, but there is reference to the existence of a protective order that may make it more efficient, is probably not the right term, but may make it easier for appellant to try to get that record from someone who's not bound by a protective order than someone who is.
Regardless, it's not inappropriate. The request to OA was not inappropriate.
Not inappropriate. No, it's not necessarily functional.
Is there any reason they can't go back and send the request tomorrow to Camp Hill again?
They can do that at any time. Absolutely any time. One other statutory construction issue that demonstrates the the holistic operation of all these provisions is 703. 703 is the sort of inception of the right to know process that requires requesters to send the request to the agency open records officer of the agency from whom they seek records. Again, that's being end run here, as the majority recognized below, by this request to the Office of Administration.
Well, but the argument is they're not. The argument is that they're not Camp Hill's records. They're OA's records in the possession of Camp Hill for the sole reason that you contracted away your responsibility to police JNet.
And I don't think that is an accurate representation of how either JNet or the right to know law treats those kinds of records. Because in this case, we're not talking about a situation where, and we can go back to the Wilkes-Barre-Scranton Barron's case and talk about an authority there, and that authority's whole purpose was to operate this stadium and minor league ball club and operate, the vending, the amusements, everything associated with it. And it was recognized that, those records in the possession of contractors are directly related to a governmental function. Well, in this case, we've got that flipped completely on its head. In this case, we've got criminal investigative processes, criminal investigative undertakings engaged in by police departments, and those police departments come to OA and say, hey, we need help. We need the ability to try to find all of these criminal justice records that exist throughout the Commonwealth, and we just need a setup to do it. Well, OA hasn't sort of delegated any of their authority to these criminal justice agencies in order to make that happen. Instead, these criminal justice agencies have said to OA, hey, we want to contract with you. We want you to just sort of give us the infrastructure. We're going to do all the work. That's not OA delegating any of its governmental functions. That's OA keeping its governmental functions.
Under this user agreement, OA is really a passive instrument.
That's right. That's exactly right.
There's nothing under any of the agreements that forces OA to conduct an investigation. In this particular case, the investigation or any kind of misuse of the JNet materials would be incumbent upon Camp Hill Police Department to initiate their own investigation and then report it upstream to OA to the extent that they had it.
That's right, and it falls to the JTAX.
But that's not what this case is about, is it? I mean, the case is about the documents.
And the documents are...
The documents would be the investigatory records they're looking for, or the access information.
Apparently, it's the user records that are product of or part and parcel of Camp Hill's, and I hesitate to use the term investigation because I don't know what they did, but Camp Hill's observations into this officer's conduct if they existed.
But you would agree that that OA has a responsibility to take adverse action, potentially to law enforcement officers, limit their access to JNet, maybe an entire police department in the event of misuse of JNet, to basically cut off access to the system.
I would say that OA has an agreement to or an opportunity to take that action. I don't know that I would say they have an obligation to do X, Y, or Z because ultimately these functions flow not from law but from OA's simple agreement, as I said, to do what these police departments have asked.
Isn't there a law that authorized OA to create JNet?
Just the executive order.
Your executive order.
I believe it's just the executive order. Yeah.
Permit me to ask this question.
Certainly.
Following up on Justice McCaffrey's comment, going to Camp Hill, if I understand correctly, the Office of Administration, you are the cabinet level position that oversees IT and cybersecurity, correct?
In part, that's correct.
So you have a contract with the police department for their access to JNet, which is everybody's personal information collected in one field per se. You get FBI records, you get state, you get local. That being said, if you're in charge of cybersecurity as part of your government duties, and an agency and the individual submits a request for a breach of that government security, why isn't it your responsibility to do an investigation?
That's a great question. That's because there are two different, and probably more than two different areas of operation of OA. So OA is certainly responsible for cybersecurity as to the Commonwealth's records and infrastructure. It's what they operate, it's what they maintain. JNet is different from that because JNet is not a system whereby the Commonwealth's benefit information, for example, is stored, whereby the Commonwealth's, you're not going to find your welfare records there, you're not going to find your workers' comp information there. JNet is merely a portal that connects customers and customers, connects criminal justice agencies with certain criminal justice elements that reside both within and without the Commonwealth. So insofar as JNet is concerned, those activities with respect to breaches, and I've used that term loosely because Breach Act is a separate thing that's not really relevant here, but with respect to, we'll say, unauthorized access, is an area of concern for the data owners. OA doesn't provide, general cybersecurity provisions as to the data owners and the data customers. It's not the Commonwealth's sort of resource network that we're talking about here. And that's not something that OA, in any event, has contracted away to Camp Hill or has delegated to Camp Hill. Rather, Camp Hill keeps what Camp Hill had, which is the criminal justice activities that they're using here and potentially the non-criminal investigative observations that they are alleged by appellant to have engaged in.
All right, I think we understand. It was very well presented, and if I had known how in-depth this argument was going to be, I might have offered CLE credits to the attorneys on the right to know law.
That's next week, Your
Very well
Honor.
done. Thank you both. And Mr. Minner, would you adjourn or recess us for lunch until 1:15?
Thank you.
1:15? Good afternoon. I'm sure it's no reflection on you, but you have cleared the courtroom. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Lowrey, representing the Commonwealth, Mr. Quigley, representing Mr. Lowrey, Mr. David Bassford.
Good afternoon. In this case, Aplt was stopped by police after driving out of a Wawa parking lot and turning onto Route 309 without using a turn signal. After further investigation, the officer discovered that Aplt was driving with a suspended license. The officer cited Applt's failure to use a turn signal as the basis for his traffic stop pursuant to Section 3334 of the Vehicle Code. Aplt sought to suppress evidence from the traffic stop on the grounds that the officer had no reasonable suspicion or probable cause to stop him. The suppression court denied the motion, finding that Officer Carr had probable cause to stop Aplt because Section 3334 requires drivers to use a turn signal before entering a traffic stream from a parked position. The Superior Court reversed, holding that Section 3334 imposes a duty on drivers to use a turn signal only when their vehicle is already upon a roadway, and thus does not apply to vehicles turning from a traffic way, such as a parking lot. The Commonwealth appealed, and we granted review to consider whether the Superior Court erred in holding that Section 3334 of the Vehicle Code does not impose a duty on drivers to use a turn signal when turning a vehicle onto a roadway from a parking lot. Please proceed.
Good afternoon, Madam Chief Justice, Justices. John Fegley from the Bucks County District Attorney's Office. The Commonwealth today is asking this court reverse the Superior Court's holding that in order for a vehicle to be required to use a turn signal upon entering the traffic stream on a roadway, it must also have been parked on the roadway to begin with. That holding is illogical, as no one parks on a roadway.
Why is it required under the Superior Court's understanding that the vehicle already have been parked? Because the language of the statute says, upon a roadway, no person shall turn a vehicle or move from one. So that encompasses situations where the car is already in motion too, right? Not only parked.
Correct. Those two provisions also in that paragraph contemplate the vehicle being on the roadway to begin with, because the movement as such requires it.
Which is unsurprising, since the entire provision begins with the word upon.
Correct. The Commonwealth believes it's more reasonable for the third provision about entering the stream of the traffic based on the definition of roadway being defined as that which is devised for the ordinary vehicular travel and excluding shoulders and berms and places where vehicles do not ordinarily travel.
But there are all kinds of roads. In fact, my own neighborhood and well, I guess all over the state, there are any number of situations where cars are legally parked and they enter the traffic stream from a parked position on the roadway.
Well, actually, the definition of parked in the Vehicle Code defines permissible parking as being off the roadway. So they would not be legally parked if they were parked on the roadway.
Well, if that's the case, then that's contradictory to the statutory definition of roadway. Because I'm talking about on the roadway parking.
So on the roadway parking, again, the definition of parking has permissible parking and impermissible parking. Permissible parking, by definition, is off the roadway. Permissible parking excludes what's commonly known as double parking if you're temporarily stopped to unload.
Not talking about double parking. Perhaps this is a frolic and detour, but then I think there is an incoherence or inconsistency within the statutes themselves, because it's routine and ubiquitous that cars are parked legally on roadways, and the definition of roadway is is exclusive of the sidewalk, berm, or shoulder.
Correct. And that would be my understanding of where the vehicles would be lawfully parked, on the sidewalk, berm, or shoulder, that portion of the highway. But the roadway is the portion of the highway in which the vehicles are limited for traveling. They're in motion on the roadway. Where they're parked would be considered the highway and not the roadway. So I cannot, when Your Honor is talking about lawfully being parked on the roadway, which portion of the roadway would they be parked on?
Picture a neighborhood, picture anybody's neighborhood.
Okay.
A street, not a highway.
Just a regular old street in a regular old town. And there's cars parked all over the place perfectly legally. And that's not on the shoulder or the berm or the sidewalk. So I'm looking at the statutory definition of roadway. That is within the definition of roadway.
So I would consider the area that you're describing, at least in my mind, I don't believe there is a statutory definition of shoulder, but the area abutting a grass berm in which the cars would typically park, or abutting the sidewalk where cars would typically park, I would consider to be the shoulder and not the portion of the roadway or the highway in which the vehicles travel.
It sounds like you're viewing it as a highway when it's not only a highway. It could be a street, right? A city street.
Every way
Correct.
publicly maintained.
Yeah.
Yes, but
Could you pull the microphone closer?
sorry.
That's quite all right, thank you.
It's the lane of travel, whether laned or not, which is the roadway.
Nobody would be traveling on the part of the street where cars are parked.
Correct.
So that wouldn't be considered, under your definition of roadway, the roadway. It has to be an area that is for the travel of cars, not for the parking of cars.
Correct. That is our contention. And with the definition...
If somebody parked in the roadway, they'd be blocking traffic.
Absolutely. And so if, by the Superior Court's construction with that definition of what we're arguing, the only way the statute would be applicable if someone was sitting blocking traffic or in a two-lane road where traffic was going around them and they left their block rather than moving forward, moving into the lane, the traffic flowing around them. Under the Superior Court's interpretation, with that understanding of the lane of travel and the traffic stream, that would be the only time someone would have to use a turn signal to get into the traffic stream. Everywhere else, they would be leaving a portion of the highway not designed for vehicular travel, which is an absurd construction when you read the entirety of Section A of 3334.
So are you saying then that the only non-absurd construction is the antiquarian usage of upon, like once upon a midnight, or upon a clearing I happened once upon a time? Why would the legislature use upon a roadway instead of saying no person shall turn a vehicle onto a roadway? Isn't that the way we would expect them to write it if it's your construction?
Well, because they brought it into the same paragraph listing the three times. Had they broken it out and had turning the vehicle, changing the lanes, or turning onto the roadway in three separate paragraphs, then that would be an unnatural construction. But they lumped them together and used upon a roadway to describe all three. And it made it a little awkward to phrase it when you take out the rest of the words that don't apply to this particular movement.
But I mean, if I'm understanding you correctly, if you simply took the words upon a roadway, you removed them, and then you inserted onto a roadway after vehicle, wouldn't that be the statute that you want?
It would be a construction of the statute. But even here, if we stay with upon a roadway, and have it modify just entering the traffic stream, it's the entry of the traffic stream that happens upon the roadway, just like the turning of the vehicle is on the roadway.
But he's in the traffic way. He's in the Wawa parking lot when he makes the turn. So when he begins to make the turn, and there's the roadway out there, he's not upon it.
Well, when he enters the traffic stream, he is upon it. Because the traffic stream is flowing on the roadway.
So then he's already there.
Yes. So that's the construction the Commonwealth is arguing. The upon the roadway governs the entry of the traffic stream, not the preceding parked position.
Well, but upon a roadway, no person shall turn.
Shall turn a vehicle.
very, right, shall turn a vehicle. It's a very, like Yoda wrote the statute. Upon a roadway, no person shall turn.
Or Robert Frost, who were,
Or Robert Frost. Well, Yoda, Robert Frost. Just tells you everything you need to know.
This is Frost's less famous work.
Two highways diverge.
Right. But upon a roadway, no person shall turn. That's what the charge was on here. Upon a roadway, no person shall turn. Not the shall turn a vehicle. Not the move from one traffic lane to another. Not from enter the traffic stream from a parked position. It was upon a roadway, no person shall turn. Right, a vehicle.
Well, the argument of the Commonwealth was it was the entry of the traffic stream, not the turning.
Well, why do you? Okay, that's interesting, but why do you need that? Because it seems like there's three things. Upon a roadway, no person shall turn a vehicle, move from one lane to another, or enter the traffic stream from a parked position. So they're like three different things, aren't they?
Well, yes. So my reading of the statute and our argument was a turning on the roadway is you come to an intersection of two roadways of Main and Market, and you turn from Main onto Market. You've conducted the turn onto two roadways.
But that's not what it says. I appreciate you're making that point, but my issue with the Superior Court's decision, and maybe it's not your issue, my issue with the Superior Court's decision was that it imposed a start point. That we have to look at where they start the turn. We don't look at where they were turning. And if you just look at if the statute said no person shall turn onto a roadway, that suggests they're turning on from some other location onto a roadway, or maybe from one roadway onto another roadway.
Correct.
But that's not at least that's not what I see. It says upon a roadway, no person shall turn. And that seems to suggest that it doesn't matter where the turn started, nor does it matter where it ended. It matters where the turn happened. And if they were turning on a roadway and they weren't using a signal, they violate the statute. Why am I wrong?
That was not what we argued before the Superior Court, and I believe it was because the evidence at the suppression was not that he turned from the Wawa parking lot so much it was one of those angled merges that he was coming from.
So you're saying he wasn't turning, his wheels were not turning, he was not executing a turn onto 309.
It was more of a merge from a slanted exit out of
Then
the
he should
Wawa.
have been, then the officer could have charged him with 3324, which says the driver of any vehicle about to enter or cross a roadway from any place other than another roadway shall yield the right-of-way to all vehicles approaching. I mean, that's the yield law, and if he violated that, he could properly be cited. The question presented us, though, is did he have to use a turn signal when he turned a vehicle onto a roadway from a traffic way?
yeah.
He wasn't upon a roadway, he was on a traffic way, the Wawa lot, and then he turned onto the roadway. He wasn't charged with failing to yield.
Well, to first cover 3324 only deals with yielding to oncoming traffic. It does not deal at all with signaling. It does not deal with making sure it's otherwise safe to make the turn or to merge onto or otherwise cross.
Is merging the same as turning in your mind for purposes of this statute? Because I was looking at this as turning, and when I viewed upon the roadway, I kind of figured there are at least three positions the car will be in. It will be sitting in the parking lot, it will be part way onto the roadway, and then it will be upon the roadway.
Completing the turn on the roadway.
Yeah.
Still turning, but now you're saying there was no turn.
Yeah, you've thrown us.
What is a turn and what is not a turn, and how many degrees and an angle have to amount to become a turn are...
Well, but your question was turning. Sorry, Chief, I
A merge
apologize.
is not a turn.
The question you gave us was when turning a vehicle onto a roadway from a traffic bay. Your question that you asked us to take specifically said, this is a turn, but now you're saying it wasn't a turn.
I might have confused those. Let
me just ask you a question. Did he execute a turn in the vehicle? A turn meaning he had the wheels were not straight. He was not going straight. Did he turn his wheels to execute a turn in the vehicle?
His wheels were not completely straight to get onto the roadway.
I don't know what that means. I mean, what do you mean so you're saying not completely straight, meaning he was turning? He was moving at anything above 0 degrees?
Yes. I mean, again, we'd have to get to semantics on what degrees equate a turn to.
Well, but I think we all know how you merge and how you turn, and I think we're just trying to figure out, were you correct when you said in your question that it was a turn?
I'm sorry, I was so focused on the from the park position argument about it not mattering where the park position was to begin with, and what happens on the roadway. I might have conflated my arguments here poorly.
Well, don't you agree, though, that to be properly cited under this provision of the traffic code, he would have had to be upon a roadway?
Yes. But I'm saying from start to finish, he doesn't have to be upon a roadway. From when he gets into the car and turns the ignition on to the point that he starts driving at the full speed of miles per hour, I don't believe the statute contemplates him being on the roadway the entire time.
But I thought the citation was premised on the fact that he turned from the Wawa lot onto the roadway without using his turn signal.
Correct. But I'm saying the starting point is what doesn't matter. It's where the actions take place.
Well, but then they would have used onto instead of upon, right?
And again, if they broke them out into 3 separate actions, I believe they would have. But again, they're generally saying upon the roadway when these actions happen, not when the entirety of the action happens.
Okay, you want to move on?
Can I ask a question? Section 3324,
Yes.
do you agree that this applies to this defendant?
To this defendant?
Yes.
Yes.
Okay. And what makes you think that there's any other rule of the road that applies to this defendant other than yielding the right-of-way?
I'm sorry, can you restate?
What makes you think that there's any other provision of the code that applies to this defendant other than yielding the right-of-way? He's about to enter or cross a roadway from any place other than another roadway.
I'm not saying that provision doesn't apply. What I was saying is that it doesn't negate or change the fact that 3334 does not require all points of the action to have occurred on the roadway, because it only deals with yielding to oncoming traffic.
It deals with someone who's about to enter a roadway, which is what he was doing. He was about to enter a roadway.
Yes.
Whereas he was doing nothing upon a roadway in order to trigger 3334A. He was about to enter. I mean, if you agree with the notion that this applies to this defendant, 3324, then by definition, he wasn't upon a roadway. He was about to enter the roadway.
And there's no dispute that he was not at all times not upon the roadway. We're not disputing that Wawa was not the roadway, but he can violate both 3334 and 3324 by first failing to yield to oncoming traffic, but also not using a turn signal when he completes any of the actions to get onto the roadway.
Why would he turn on his turn signal once he has already entered the roadway? I mean, because he has to be upon a roadway in order to trigger the requirement that he use a turn signal.
Well, the turn signal statute sets forth that the turn signal must be happening before those actions are taken.
But that's what I'm saying, though. He wasn't upon the roadway. He was about to enter the roadway.
Yes, but 3334A deals with the movements that have to have a turn signal utilized before they're taken, and then subsection B talks about the timing of it. So 3334A does not speak to when the turn signal happens. 3334B does.
But it speaks to where. It
Right.
says upon a roadway. Are you? There's no break. There's no period. Let me put it this way. Can we agree that subsection A applies to circumstances, quote, upon a roadway, unquote.
Yes.
Okay, so by definition, then, it doesn't apply to circumstances that are not upon a roadway.
Yes. But I'm saying not all of the circumstances from start to finish have to be upon the roadway if those actions are taken ultimately on a roadway. If they start somewhere else and end on the roadway, then the movement described is satisfied. And then B comes in and talks about the timing of the signal at various timelines of happening before those movements.
But by definition, the signal would have under B would have had to have been given before being upon the roadway.
Yes.
Because under the last sentence of B, the signal shall also be given prior to entry of the vehicle into the traffic stream from a parked position. So if it's prior to, then by definition it's not upon a roadway and the section doesn't apply.
Well, B doesn't require, the language doesn't require the signal be given on the roadway. It governs the movement that happens on the roadway. A governs the movement that needs a signal. B talks about the timing.
I mean, sometimes cases are just papered the wrong way, and that's why motions to amend are liberally granted in the trial court.
Understood.
But there is no question about the defendant yielding the right of way, was there? There's no question in this case that the defendant yielded the right of way.
There was no testimony that there was an oncoming vehicle that he did not yield to, correct? And there was testimony that he did not stop at a stop sign in exiting, but the stop sign was on a highway, which 3101 indicates does not apply. Or I'm sorry, on a traffic way, which 3101 indicates does not apply. So while he did not stop at the stop sign, 3101 says that stop sign is not governed by the vehicle code.
That's because it was on a private property, right?
Yes.
The Wawa.
Yes.
Anything else?
Not if the court has no further questions.
All right, thank you very much. Let's hear from opposing counsel.
Good afternoon, and may it please the court. David Gastren with the Bucks County Public Defender's Office on behalf of Monty Lowrey. There is nothing whatsoever unreasonable about the Superior Court's directive to the legislature to review this statute that was enacted about 50 years ago. There is also nothing unreasonable about the Commonwealth's public safety arguments that they've advanced in support of allowance of appeal and in their brief. What is unreasonable is the Commonwealth's interpretation of Section 3334, because that reading is totally inconsistent with the statutory language. And if I could start, as the Superior Court did, by noting the Commonwealth has referenced in its filings the fact that the Motor Vehicle Code is intended to promote public safety. There's no question about that. But inherently, the provisions of the Motor Vehicle Code, unless otherwise stated, are already limited to highways. That's in Section 3101.
Yeah, but the Superior Court made a delineation between upon a roadway or a roadway and a traffic way. So my question to you is, can an automobile be on both simultaneously? I'm at the Wawa. I'm coming out of the Wawa. There's a stop sign right here. 309's in front of me, right? I can only go right because there's no left turn signal, and it's a divided highway, 309. I'm pretty familiar with the area. I stop on the traffic way, right?
Correct. At
the stop sign. When I roll into the turn, can I be on both the traffic way and on the roadway at the same time?
I believe so. I do. But
why doesn't 3334A apply?
Well, Section 3334, our position is that the statutory language is unambiguous. Those first three words, upon a roadway.
You just answered my question, though. I can be on the traffic way and upon a roadway. If I'm making a right-hand turn and I'm upon the roadway, doesn't 3334A apply?
I don't believe it. I think the legislature would have to make clear in the language of the statute that it intends for these provisions to apply when a situation, as you've described, maybe a vehicle is both on a traffic way and a roadway at the same time. Maybe it's on a driveway and a roadway at the same time. It's our position that the clear statutory language upon a roadway, it's clear limiting language that applies to the entirety of Section 3334.
Well, your view of upon is onto. Onto a roadway, no person shall turn.
My view of,
Or when entering.
Is that, am I wrong?
I believe
That the turn has to originate from something other than a roadway onto a roadway, or from a roadway onto another roadway.
my argument as to what upon means, and I don't think there's a dispute, it means on. I think had the legislature chosen to use the word onto.
Okay, so on a roadway, no person shall turn. But you just acknowledged to Justice McCaffrey that your client was turning on the roadway. He didn't start the turn on the roadway, but he at least engaged in a turn on the roadway at some point in time.
I don't believe that he was turning on a roadway as the statute is written.
Now I'm confused.
How was he not?
There's a turn. A turn is a continuum. There's a start to the turn, there's an end to the turn, but the turn is a continuum. Do you agree with that?
I would agree with that.
At any point in time in the continuum, was your client turning on a roadway?
It's my position. No, I don't believe he was, because
Is it your position you have to be on the highway, the roadway, and make a turn, as opposed to being coming out of a parking lot and turning onto the highway? Is that
exactly, because that's what I believe the statute requires when it says upon or on a roadway.
But it doesn't say start. It doesn't say started on the roadway. It doesn't say it doesn't focus on what. I don't disagree with you. I think your construction is your position as to what the statute should mean is reasonable, but I don't see any temporal language that says we focus on where the turn starts.
I think that has to be presumed based on the absence of anything in the statute.
Well, would you be well placed to presume it, given the language that says unless and until the movement can be made with reasonable safety nor without giving an appropriate signal? The use by the General Assembly of the words unless and until provides a temporal element, suggesting that that the signaling requirement doesn't kick in unless and until you're upon the roadway. Would you agree?
I would. I think that the language of the statute requiring you to signal prior to initiating the movement is what should be controlling here. And again, the legislature did not, as it could have. This court has asked several questions regarding Section 3324, which deals with yielding. I would ask the court to take, and it's reproduced on page 17 of our brief, the language of that statute, which I think all parties are in agreement applies to this situation.
Period.
Is totally different than the language in 3334. 3324 provides that the driver of any vehicle about to enter or cross a roadway from any place other than another roadway. So that section does not contain the very strict limiting language that's contained within Section 3334. It refers to vehicles about to enter or cross a roadway rather than on a roadway, which to me suggests in Section 3324, the legislature doesn't care where you're coming from. As long as you end up, you're about to enter or cross a roadway. As long as you end up on a roadway, that's what counts to the legislature.
Is it your position that the police officer cited the wrong statute?
No.
I don't believe that there was sufficient testimony presented at the suppression hearing to. I do believe he cited the wrong statute. I'm not conceding that Mr. Lowrey violated Section 3324 based on the record at the suppression hearing, but I do believe that he cited the wrong statute and that 3334 is completely inapplicable to what happened here.
Based upon the language of 24.
But comparing the language of 24 and 34. There is a separate issue that, in my view, it was certainly glossed over in the trial court's opinion. But there is the additional language that requiring a person to enter the traffic stream from a parked position. And it's our position that regardless of this court's determination as to what the language of Section 3334 upon a roadway, regardless of how this court determines or decides that issue, I believe the testimony from the suppression record makes clear that Mr. Lowrey was absolutely not entering the traffic stream from a parked position. The testimony of Officer Carr, elicited by the Commonwealth, was that he was driving through the Wawa parking lot prior to exiting onto 309. So, regardless of this court's decision as to the upon a roadway, which, again, we believe is very clear and definite, even if the court disagrees as to that issue, we don't believe Mr. Lowrey was entering the traffic stream from a parked position. The Commonwealth concludes in its brief before this court that he was, but that is certainly disputed on our end, again, due to the officer's testimony that he pulled out of a parking spot. There's no question that at that point he was parked, but then he drives through the Wawa parking lot onto the exit onto 309.
But as you read 3334A, he would have had to have been parked upon a roadway. Am I correct? Upon a roadway modifies shall turn a vehicle or move from one traffic lane to another or from a parked position.
Exactly.
So he would have had to have been parked on
Yes, under
309.
Under the reading of Section 3334, based on that limiting language, he would have had to have already been parked upon a roadway. Justice Wecht pointed out that it appears that the vehicle code may be a little bit incoherent as to this issue.
This case is proof of that fact.
Yes, I don't disagree.
And by the way, I checked, this, unless I'm mistaken, this has been on the books like this since 1976, so on the 50th anniversary of this morass, we could hope the legislature would revisit it.
Yes, but to return to Justice Wecht's earlier point, we believe that there are certainly circumstances where vehicles can be parked on roadways. I would direct the court to, it is not a part of our brief before this court, but in our reply brief before the Superior Court, which was made a part of the reproduced record on page 129A, we list several provisions of the vehicle code that explicitly provide for parking on roadways. It appears the legislature has determined that in some instances it's just not possible to park anywhere else.
South Philly, Squirrel Hill, lots of places.
Yes, and so those sections of the vehicle code certainly take that into account. At the same time, I recognize that the definition of parked, at least the first prong of it, does refer to vehicles off the roadway, which would leave number 2, meaning vehicles that are parked when prohibited. So I certainly understand there's tension there, but it's our position that, exactly as Justice Donahue said, under Section 3334, Mr. Lowrey would have had to have already been parked on the roadway prior to entering the traffic stream from a parked position. With regard to that point about ambiguity, I have to take the opportunity to note that in the event that this court finds that the plain language of 3334 is ambiguous, it's certainly our position that that ambiguity should be resolved in favor of Mr. Lowrey. Unless the court has any additional questions, that's all the argument I have.
Thank you very much. Thank you both.
Thank you.
Thank you.
Call the next case, Mr. Miller.
Different from Fegley's last case in front of us. We got quadruple murder, remember?
I would like water. Yeah, thanks.
Good afternoon. In this direct appeal, the ownership interest in a real estate company was placed in a revocable living trust by its settlor and trustee. Upon his death, pursuant to the terms of that trust, the ownership of the real estate company was transferred to Aplt, which is another trust also established by settlor for the benefit of his wife. We must address whether the value of the real estate company is subject to Pennsylvania's realty transfer tax under the Pennsylvania Revenue Code, where the code excludes from the transfer tax transfers for no or nominal consideration from a trustee of a living trust after the death of the settlor of the trust. Please proceed.
Good afternoon, Madam Chief Justice. My name is Anthony Kowalczyk. I'm a Deputy Attorney General for the Commonwealth of Pennsylvania. I represent the Commonwealth in this appeal. I think the facts here are stipulated, so there really aren't any disputed facts. The narrow issue that we appealed concerns the construction of subsection 9.1, which lists, and we contend, exemptions, not exclusions. The first thing I want to point out to the court is that the Commonwealth Court's opinion on its face did not acknowledge it was not applying or considering what rule of statutory construction needed to be applied. They specifically stated in the panel opinion before the exceptions were filed, and then again in the second, in the en banc opinion, that it was not deciding whether subsection 9.1 was an exclusion or an exemption. Now, this court in 2013 in the Miller case specifically said that it wasn't necessary to consider that issue when the statutory language is unambiguous. And in Miller, the court determined that there was, in fact, unambiguous language that rendered consideration of that unnecessary. But in this case, I think it's pretty clear, not only in hindsight, given that the panel and the majority viewed the statute one way and President Judge Cohn-Jubileer viewed it differently, that we are dealing here with ambiguous language in subsection 9.1 within this statutory scheme. And the reason we know that is the word property is not defined. We're dealing with realty transfer taxes. We're dealing with taxes that apply to transfers of real estate, and we have a separate subsection, subsection 20, that explicitly applies to transfers of ownership interests in real estate companies. And the legislature showed when it enacted subsection 20 that it knew how to refer to an ownership interest in a real estate company and exempt it from the realty transfer tax. So that, at a minimum, I think, creates an ambiguity within the statutory framework requiring resort to the canons of statutory construction. Now, under this court's 2005 decision in Crawford Central School District, we think clearly this subsection 9.1 is an exemption. It is not an exclusion. It's actually interesting that Stump Road actually, in their brief, relies on Crawford Central School District, but that decision actually supports us because in that case, you were dealing with a situation in which statutory language was labeled as exclusions, but this court held that the language actually constituted, the provisions constituted exemptions because of the way they operated. And clearly, subsection 9.1 operates as an exemption under Crawford Central School District because it establishes a set of criteria that has to be met to render a transfer exempt from taxes that would otherwise be applied. So if you actually go to the next step, which the Commonwealth Court did not, and apply the rules of statutory construction, we're dealing with an exemption. Now, where the Commonwealth Court went off course is it didn't focus on the statutory language the way that President Judge Cohn-Jubileer did. The Commonwealth Court, unfortunately, looked to two of its prior decisions, the 1988 Healthcare Group Homes Center's decision out of Pittsburgh and the Equitable Life decision out of Philadelphia in 1993. And those decisions literally did not interpret this statutory language. Not only did they not interpret subsection 9.1, but they did not even apply to an ordinance that exempted anything from taxation. They simply relied on this general proposition that there's no distinction between a direct transfer of real estate and a transfer of an ownership interest in a real estate company. And we think that when the canons of statutory construction are properly applied, we're dealing with an exemption, and that means it has to be strictly construed in favor of the taxing body and against the taxpayer. And of course, that would require reversal of the Commonwealth Court's decision. We also think that the canon of constitutional avoidance also counsels in favor of our construction in this case, because the 1993 decision that the Commonwealth Court relied on, Equitable Life, invalidated and severed a 1% exemption from the Philadelphia Ordinance at issue in that case, and applied this court's decisions in Kelly versus Caladnar and Salisbury versus Bethlehem Township, and found that there was a uniformity violation in the way that the Philadelphia Ordinance operated. And the uniformity clause, of course, allows taxes to be imposed on different classes, but not the same class of property at different rates based on the quantity of property, as this court has said in cases like Nextel and Mount Airy. And the problem here is that if they are treated the same in the way that the Commonwealth Court treated them, that creates a problem, because the way that the ownership interest, the realty transfer tax operates in the context of a transfer of an ownership interest in a real estate company, is that it's not triggered unless 90% of the interest of the ownership interest is transferred during a 3-year period. And if you have a situation where where you have shares being transferred that don't meet that threshold, there's no tax at all. Whereas a direct transfer of real estate, you would have a situation where the interest would be taxed on the share of the interest that's being transferred is taxed at 1% under the state realty transfer tax, regardless of whether it meets that 90% threshold. So we think that differential, in order to avoid the potential constitutional conflict, we think that the court should apply the rules of statutory construction, hold that it's an exemption, apply Crawford Central District, reverse on that ground. That allows the constitutional question to be avoided. And that also allows the regulation, subsection C, to be applied that the Commonwealth Court disregarded without really analyzing the statute, and it appears to have disregarded specifically because it found the regulation inconsistent with 2 decisions that it had issued interpreting ordinances. And obviously that's not what the court needs to look to. So we're asking the court to reverse the Commonwealth Court's decision for the reasons that we stated in our briefs and for the reasons given by President Judge Cohn Jubileer in her dissent. That's a discrete issue. I can answer any questions you have, but I don't really have anything else unless the court has questions.
Any questions for Mr. Kowalczyk? No, thank you, sir, very much.
Thank you, Your Honor.
Let's hear from Mr. Burkhead. Did you have questions?
Okay, I'll ask him.
Good afternoon, Madam Chief Justice, Justices. May it please the Court, Kevin Burkhead appearing for Appellee 430 Stump Road, LLP. The appellee's case is very straightforward. We disagree with the Commonwealth that the statute is ambiguous. The Commonwealth Court, in addition to citing the cases that Mr. Kowalczyk just talked about, also walked through the statutory language of the realty transfer tax statute. In the statute, Section 1102C imposes the realty transfer tax and refers specifically both to transfers of real estate by deed and acquisitions of real estate companies. Section 1102C3 states, quote, "The tax imposed by Section 1102C shall not be imposed upon," end quote, and then goes on to list numerous transactions that are outlined in 25 subsections that follow. This first sentence of Section 1102C3 is structurally and grammatically part of every following paragraph and subparagraph. The Commonwealth never discusses this first sentence or explains how or why it does not apply here. As Mr. Kovalchuk discussed, one of the exclusions contained in 1102C3 is a transfer for no or nominal consideration from the trustee of a living trust after the death of the settlor to a beneficiary of the trust to whom the property was devised or bequeathed. That is precisely what occurred in this case.
Well, except that statutory language says property, not interest in a real estate company.
Well, it says property, which is not a defined term in the statute. Both real estate company and real estate are defined terms, Your Honor. So it seems to me the legislature purposely used the term property, which could encompass both.
Okay, so you're saying that property in that exemption applies to ownership interest in a real estate company or the actual real property.
I certainly think it could. You know, basic property law would say that there's real property and there's personal property. Personal property would include an interest in a partnership, as in this case, or an LLC.
Yeah, but this isn't a personal property tax statute. This is a realty transfer tax statute. And,
True.
And you have a regulation that went through the the Commonwealth Documents Law, the Independent Regulatory Review Act process. General Assembly had an opportunity to chime in when the regulation went through. Regulation has been on the books for a while. If we look purely at the regulation, does your client win?
No.
Okay. So you would have to show then that the regulation is in conflict with, can't be harmonized with, the language in the statute. Where is the conflict, the inability to harmonize the regulation with the statute?
Because the statute says the tax imposed by Section 1102C shall not apply to the following.
Right.
Which then includes Section 9.1 concerning transfers from a living trust to the beneficiary of the trust.
So you're saying it's an unreasonable, but it says property though, and that seems to be where the regulation, and there's another exemption that deals with real estate. I think your argument would be a good argument from a statutory construction perspective if the regulation didn't exist. You kind of have to start with the regulation first and say, where is the conflict? And I'm struggling to find the conflict. I might think that yours is a fair construction of the statute, but the regulation is just as legally binding as the law, as long as it's consistent and not in conflict with the statute. And why is their construction that when it says property in one exemption and real estate in another, real estate ownership in another, that exemption was only intended to mean the actual property, the actual realty being transferred?
Because I continue to go back to the first sentence of the section entitled Excluded Transactions, which says, the tax imposed by 1102C shall not be imposed upon the following.
Right.
I mean, to me, that is specifically referencing real estate companies because that's part and parcel.
Some of the exemptions deal with real estate companies themselves, right?
Subsection 20 deals specifically with real estate companies.
Specifically with transfer
and
of
family
ownership
farms,
interest in real estate companies.
And it sets forth a broader exclusion for transfers between family members for real estate companies and family farms. So I would suggest to the court that that is the purpose of paragraph 20, that, you know, we're allowing transfers for real estate companies and family farms between cousins and things that are not excluded for purposes of direct transfers of real estate. The Commonwealth is sort of implicitly saying that because that's the only subsection that mentions real estate companies, that therefore it's the only subsection that applies to real estate companies, but that's not what the actual statute says. The statute says the tax imposed by Section 1102C does not apply to the following, which encompasses all of the subsections.
Well, but again, but the one exemption you're arguing says property. It doesn't say real estate company. And you're saying that that doesn't matter, that's completely unambiguous. The General Assembly absolutely, when it said property, meant real estate company or the real property itself. Their construction and their regulation is just completely bonkers and conflict with the statute.
I think that's one way to read it, Your Honor. I think another way is to say, well, as Your Honor noted, this is the realty transfer tax statute and tax that we're discussing, the tax itself is on the value of the real estate, whether it's a direct transfer of real estate or a transfer of a real estate company, right? When a real estate company crosses a transfer of 90% of the ownership interest and becomes an acquired company, it's essentially a deemed sale of real estate. So we could say, well, it's an exclusion or it's an exemption. We could look at the word property. I think it's a bit circular because you can still say, in this instance, the legislature intended that transfer from a trust after the death of the settlor would be excluded from taxation.
For you to win, you have to say what they're saying can't be what the General Assembly intended. Can't.
I don't think anyone reading the statute without having reference to the regulation, which wasn't issued until 2 years later, I believe, would conclude that none of these exclusions apply to a transfer of a real estate company because of the language in the first sentence of 1102C3.
Counsel, can I call your attention to subsection 9.1, where the word property is used? It's followed by is devised or bequeathed. Is real estate devised personal property bequeathed?
I believe that is correct, Your Honor.
Well, isn't that the clue? That property both refers to property that can be devised, which would be real estate itself, and bequeathed would be the real estate company.
That certainly makes sense to me.
Why use both words if it's not referring to both personal and real property?
I think that's an excellent point.
Is that reasonable?
Absolutely, Your Honor. Thank you.
Because I can't think of another reason to use both devised or bequeathed.
Right. A devise in estate or trust law refers to real estate.
And bequeathed refers to personality.
Correct.
Okay.
Any other questions? All right, thank you both very much.
Thank you.
Mr. Minner, is there any business to come before the court? All right, would you adjourn? Let me just thank a few people first. As this concludes our 2026 spring argument sessions, I would like to thank PCN for broadcasting our sessions for educational purposes. We appreciate it very much. And our court crier, Brian Minner, and our pathonetary, Caitlin Gorman, and her staff, our court security, John Evans, Gary Shovlin, and Scott Town, as well as the Capitol Police. Mr. Minner, you may adjourn the court.